Ladies and gentlemen, we're going to get started, and I'd like to actually start off if everyone would rise and we can have the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. They want me to finish just do the closing and stuff. All right, ladies and gentlemen, thank you all for being here. We have basically 2 hours. We have a list of speakers, people that are in order that they contacted us to speak. I'm Senator George Borrello from 57th Senate District, and I'll have each of them introduce themselves, but we have Rob Ort, we have John Flanagan, and we also have Pat Gallivan here. We have Senator Ransenhoffer should be joining us in a little bit. I'm going to kick it over to Leader Flanagan for a few opening comments, and then we will move down and start our testimony. So, thank you, Leader.
Thank you, Senator Borrello. My name is John Flanagan. I'm a state senator from Long Island. I serve in the county of Suffolk, and I've had this privilege and distinction of serving in government now in my 34th year in the legislature, and I can't think of a time where we face more important issues for the people that we represent, our constituents, the taxpayers of the great state of New York, and public safety is our number one overarching concern. We have a lot of obligations in state government, but my colleagues and I feel if people do not feel safe in their communities and they're not being properly taken care of, we have to move and we have to change and we have to do things differently. So I am elated to be here with Senator Borrello, our newest colleague, and gentlemen to my left and right who are both experienced legislators, great public officials, and people are wondering, what am I coming here from Long Island for? This is important. This is really important. We want to speak with a unified voice. We want to make sure that we're doing the best thing by the people we represent. We don't think that we're at that juncture right now, and we want to hear from people who are our guests for today, Senator Borrello, Senator Gallivan, Senator Ort. Thank you for having me.
Thank you very much. Gentlemen, would like you to say anything before we get started?
Oh, sure. Good afternoon, everybody. Thank you all for being here, especially those that are here to testify, those concerned about the issue. I think this is the most significant issue we face in the state is our concern for public safety, and there's no question the state is less safe than it was a year ago. When you put laws together, professionals, communities, people should be engaged. We did criminal justice reform a few years back, raised the age, where everybody was engaged and a decent product came out of it. Here, the old laws were not perfect by any means. There was problems with it, no question about it. There are legitimate concerns about biases in the system, whether it's ethnic, racial, or economic. But the way to make change is to engage people and engage everybody across the board out of concern for all people in the state, whether they're a defendant or whether they're the law-abiding citizen and community members or victims. This needs to change. We're going in the wrong direction. We believe the way to do it is you pull this back now, repeal it, start all over, engage people, and do it right, putting public safety first. So thank you. I look forward to the testimony.
Thank you, Senator Gallivan. Senator Ort, would you like to?
Yeah, I don't want to belabor it. We want to get along with the hearing and hear from our folks in uniform and people who work in criminal justice every day. But I always want to echo what has been said. This didn't happen last year before this law was passed. These hearings didn't happen because the decision had already been made. This was about a political narrative. The decision was already made. We were going to pass this, and then we went back from there. As opposed to saying there's a problem, let's have discussions and work towards a solution. The solution was determined before. So any hearing or anything that was done or any discussion was just reinforcing the political decision that had been made to pass the reforms that were done. And what we know now is undeniable of the crime statistics that we've seen. And I expect we're going to see more of that because the laws that were done, keep in mind, 90% of arrests are now appearance ticket arrests. 90%. And it encompasses a host of violent crimes, despite what the law says about nonviolent a host of potentially violent crimes. But, as my colleague said, the old system wasn't perfect either. And I will tell you that there are changes. Speedy trial was part of the reforms that we did last year. No one's complaining about that. That's a good thing. That is a good thing that every American of all stripes, every New Yorker of all stripes and backgrounds, is guaranteed in the Constitution, a speedy trial. So there are things we can do, and there are people in this room who can tell you flat out where the problems in the system are, because they know it every single day. It's not just on the police side. The police can tell you where the problems are. The DAs can tell you where the problems are on the people who are in court. They can tell you, no, this is wrong, we should make this better. But we should listen to them and make that determination. So that's why we're here today. I commend the leader. I commend my colleague George Borello for hosting this, and certainly my colleague who was a sheriff for many, many years here in Erie County. And hopefully we're going to hear some great testimony today. And hopefully those who make the decisions today in Albany will be hearing and take this to heart as well. So thank you very much.
Thank you, Senator Orr. Let me just read some rules of engagement, if you will. First of all, the speakers have been organized on the day and time that they confirm their attendance, starting with those who are scheduled first and proceeding from there. When called, we'll have each participant come up to the table here and give their testimony. In the interest of time, we have a lot of people on the list. We'd like to keep the comments to approximately 5 minutes, and then we'd have a time for questions for the senators to bring questions to those that are speaking. And we'd like to try to limit that to 5 minutes. Any speaker who's not able to accommodate this, or we're not able to accommodate, excuse me, you can submit written testimony to this task force. You can speak with one of the members of staff that are here, or you can email me at borello@nysenate.gov. That's 2 R's and 2 L's, borello@nysenate.gov. And please, we'd like to remind the speakers to speak clearly into the microphone, and we will go ahead and get started. I'm actually going to start off with our sheriff in Chautauqua County, Jim Quattrone, and actually he'll be joined by Sheriff Tim Howard. We're going to give them a little extra time since they're taking their testimony together. They were originally supposed to testify separately, so we thank you both so we can accommodate some additional speakers. Thank you very much.
Thank you. We first want to start by saying we appreciate the invite. We appreciate the work that you are doing to see this legislation hopefully repealed. As I heard the four of you speak, it gave me great hope to recognize that there are people in Albany that are listening and are having a common sense approach to this reform that we need. I think each one of you mentioned there is a need for the reform, but not to the extent that it has been happening. We want to be focused on public safety, and part of that is from Sheriff Howard and I's point of view, we're going to be talking mainly about the jail issues and the issues we've had with incarceration rates, leave some of the public safety issues to our colleagues in the different police agencies that are here. For Chautauqua County, our jail population currently is down by about 33%, which equates to about 85 individuals. Those 85, I can't say for certain that that's all as a result of the bail reform, but I can say that there's 85 individuals that are out on the street that could be incarcerated receiving services that are desperately needed by some of them. Some people who are getting services that through different mental health or drug treatment. But the danger is some of these individuals are reoffending. Specifically, we've had one individual in a small township who is not showing up for court already twice. Are we seeing our warrants increase in numbers? Not necessarily from the county perspective, and that's because many of our town courts only convene once or twice a month. So they are making their outreach to the offenders, reminding them that they have to come to court, and then waiting until the next time they show up for court or go to court to issue those bench warrants. So we are expecting an increase in bench warrants and failure to appear starting in March or April. The danger, again, there is we're going to have to send our officers out to find those people. That takes away from patrol duties and activities that are keeping our communities safe.
I agree with all the comments that were made by my neighboring sheriff. We discussed already what we would try to get out today. I think I hate statistics, but I think that may paint a picture here that a year ago, in January of 2019, our average population in the jail was 830 inmates per day. For January of 2020, it's down to about 660, about 170 inmates less, just here within Erie County. As was said by my brother sheriff, I think most of the comments regarding what it means to the community is probably best expressed by the other police agencies that are represented today. But I think if we looked at warrants that were handled by the Erie County Sheriff's Office, last year we executed about 100 warrants per month, so pretty close to 1,200 for the year. It's about the same. So far, 100 warrants were executed by our office in January of this year, so it's about the same as last year, but the impact of this new legislation hasn't taken effect yet, so we anticipate that it will be a very significant increase in that. One of the...
Could you please let him speak? Thank you. Please let him speak. Thank you. We'll all have an opportunity. Thank you.
One other thing that's very clearly, we think, been overlooked, and no one has questioned any of the sheriffs in the state about this before the legislation was passed, is to take an honest look at the services, the pretrial services that are offered in the jails across the state, that are offered to inmates that they will no longer be eligible for. We have one of our programs at the Erie County Jail just won the Innovative Award Program for all of New York State for 2019, and that was referred to as Project Blue, which specifically addresses recidivism by addressing inmates at their pretrial stage. So the programs that inmates previously went through in jails, it was alcohol withdrawal, it was drugs, it was anger management, they no longer will be able to obtain these services from outside the jail. And you say, well, maybe they are offered in the community. If that's the case, and they were offered in the community and available to these inmates, the inmates did not avail themselves of that opportunity. However, they did avail themselves of it while they were in jail. We've had numerous parents that have called the different sheriffs across the state and actually pled with these sheriffs that they would find their son and daughter that were addicted to opiate drugs and find them and bring them to the jail and incarcerate them in the jail, because otherwise the parents feared that the next time they would see their child would be in the morgue. We have last year at this time 26 inmates going through withdrawal of different substances in the jail. At this point this year, it's down to 16. Again, a very significant reduction in the number of inmates that are availing themselves of those services. Certainly forgotten in this is veterans that often are brought to the jail having no place else to go. We have a special housing unit for veterans where veterans help other veterans find their way home. We recognize these were once productive members of society that after going and serving honorably in the military, somehow got lost before they got all the way back home. So these services that are being provided to veterans will, they will no longer be in the jail to avail themselves of that. And probably last to point out, we have had literally hundreds of inmates that while in the jail in a pretrial status have re-enrolled in high school education programs. The programs were designed to continue. If they were sentenced and sent to another facility, the program would continue. If they were ultimately released back to the community, they were given guidance and transfer records so they could continue with exactly where they were in this educational program to continue with that following their release.
Thank you very much, both of you. And I'm going to open with some questions here, but first I do have a question. Sheriff Quattrone, when I was county executive, you and I spoke about this before it actually happened. And one of the things you said, you would need a warrant squad. And we know clearly that the state put $0 into supporting this changes in the law. But more importantly, one of the things the governor pointed to is he said that don't worry, we're going to save money in our jails and our district attorneys are going to save money. But I know that Chautauqua County already is at minimum staffing levels set by New York State. So there is no, other than a few less meals a day, there's no real savings. I'd just like if you could speak to that and the funding part of it as well.
Absolutely. State Commission of Corrections are the organization who sets our minimum staffing. The Chautauqua County Sheriff's Office, we are already running at minimum staffing. And part of that is due to classifications of the inmates. So we have many empty beds we have to have the same number of correctional officers there. The savings that we are making on the meals is minimal. You know,
You have to serve, no, but you're gonna have to serve warrants and execute those warrants. So it's
absolutely.
additional costs. So the
If-
overall burden is gonna be much higher financially as well, because, again, this law was incomplete and didn't provide funding, nor did it change any of the minimum staffing levels.
Well,
Correct?
I think the big part is that lack of consultation with those, you know, the boots on the ground and the counties, the stakeholders across the board. And that's on both sides. I think there's been a lack of transparency working with the government. And I say this is, you know, we need all sides and all stakeholders at the table to come up with a sensible criminal justice reform.
Thank you. Gentlemen, any questions you'd like to ask of our sheriffs? No? All right. Well, we thank you both for coming up, and we will move on to our next speakers. Thank you very much. Next up, I have Jamestown Police Chief Harry Snelling. Thank you very much. Appreciate you coming up from Jamestown. Please, this is your opportunity to present the insight from what's happening in the small city of Jamestown. For those of you that don't know, a little less than 30,000 people in the city of Jamestown. So, Harry, thanks for being here, and please tell us what's going on.
Okay. First, good afternoon. Senator Borrello asked me to attend today. One of the things a couple of things he wanted me to discuss was, first, how is this affecting our agency administratively? How's it affecting us operationally? And are there some public safety concerns? Going into January, there were a lot of unknowns, and, you know, especially with discovery. And we knew it was going to be a challenge to us as an agency, so we kicked it off in the mid-December and how we were going to share information with our district attorney. Because I wanted to have a window before January started, and then going into January, how it was going to affect us. Not 1 week into January, again, because of the requirements, we had to start relooking on how we were going to assist our evidence tech, because the burden of providing digital evidence, which is the biggest burden, because not only are we providing body cam footage for arresting officers, it's for every officer that's on the scene, and additionally, we have to provide video in the booking area for all arrestees that we bring in. So it's create a significant burden for us. It is a priority, so a lot of processing of other physical evidence gets put to the side because we have to meet that requirement, and we have cases that are meeting. So recently, I was forced to promote a patrolman off the streets and make him a detective, which was a great opportunity for him. However, I've taken one officer off the road, so it has a potential effect on services. And again, we're a 62-man department. It's not, we're not a large agency like the city of Buffalo, so one officer may not sound a lot to some of the bigger departments. For us, it does have some effect. So with that, and again, with no additional funding, our budgets, there's no additional funding in our budget to hire another officer. We are forced to make that happen. I heard both sheriffs mention warrants. My last city council meeting, which was Monday night, our public safety committee had asked me if I was aware of how many individuals have we recently had that have failed to appear in court. We actually track our warrants because all our warrants that are logged in city court are sent down to our department. We log them, we track them, we also store them, so we have copies. I did a comparison, just looking at January 1 through 31 of 2019. We had 69 failure to appear warrants issued through our city court. 4 were violations, 59 were misdemeanors, and 6 were felonies. For 2020, same time frame, we had a 72% increase. We're at 119, with 17 being violations, 95 being misdemeanors, felonies being 7. Is it a coincidence? Could be, but the one variable that's changed is the appearance ticket. I mean, I was asked about crime rates. My personal opinion, I think it's too early to take a look at that. There are too many variables in play. I'm more comfortable maybe 6 months, a year, year and a half down the road to start doing comparisons with crime rates. So I haven't gone through that exercise yet. Again, we're a month into it. I mean, we all have our opinions about it. We're starting to see some examples across the state. I'm sure you're going to hear some later this afternoon directly related to. One of the other things that I was asked by our local media, what were the original charges for some of these failure to appear warrants? The list goes well into the second page. I won't read them all, but I'll give some examples. Assault second, assault third, criminal contempt, criminal impersonation, criminal possession of stolen property, criminal possession of a weapon, endangering the welfare of a child, grand larceny, menacing second, resisting arrest, stalking, and unlawful imprisonment. So those are just an example of some of those crimes that are directly related to the failure to appear bench warrants that are being issued.
So unlawful imprisonment, you know, and obviously, that's some off the charge in domestic violence?
Yes, and there's a lot of these charges, and I didn't go through the exercise of going through a lot of them. I did meet with my domestic violence unit. We're very fortunate. Project Crossroads in our department we have a civilian advocate that advocates on behalf of our victims. We also have an officer that's assigned to it. One of the things that we discussed this morning, and it came up recently in court, when an officer completes a domestic incident report, one of the things that we annotate on there is comments made by suspects. And more frequently, we're starting to, and you're seeing them on the report, that, and again, I'm paraphrasing, but it's pretty much, okay, I know I'm getting arrested, but I'm going to be released. That is the mentality that we're dealing with. So the other side of that, our civilian advocate is starting to get more and more phone calls from victims that are concerned, knowing that the offenders are going to be released. Again, I think this goes back to judges having the ability to take a look at each case individually, making that determination on whether or not bail is appropriate, especially in domestic violence cases. From an operational standpoint, I think one of my biggest concerns are drug investigations. I spoke of this when we had a press conference in Chautauqua County. We're faced with a couple of options when it comes to narcotics investigations. If we execute a search warrant and we make an arrest, that individual is going to be released automatically. All drug charges are subject to no bail, with the exception of major drug trafficking. I've never seen that in my career in this part of the state. I mean, if somebody on this side can correct me, but I'm not aware of anyone ever being charged with that.
It's more federal though, isn't it really?
Well, if we're at that level, we're going federal.
Yeah.
So if we execute a drug search warrant and it's a minor amount, it's not an issue with me. If I catch you with a kilo, and that's not an exaggeration, it's an automatic appearance ticket. So that individual is going right back into the same community, the same neighborhood that we've been asked to address and remove, which continues the issue there. But more importantly, now the 15-day discovery rule comes into play. So there's a lot of information that's going to be disclosed. I know you'll hear that protective orders are an option, but we know they can also be challenged in court. There was a recent article, and I'm not going to discuss a lot, but we had an incident on Long Island where a witness was just murdered. And there's the commissioner out there is saying there's a direct correlation between discovery and that event. That is our concern, especially in these major incidents and drug investigations being one. So the other option that we have, we could execute a search warrant, seize whatever we have, and walk away, and file charges down the road, going through the process of grand jury, getting lab reports, waiting till our district attorney is ready to prosecute the case, but again, discovery kicks in. So we have very limited options when it comes to drug investigations. On top of that, potential exposures to undercover officers, confidential informants, witness testimony, and grand jury.
Okay, thank you very much. Any questions? Yes, Senator Orr?
Chief, thanks for being here, and forgive me, I may ask a couple questions, and they may be better directed towards other folks who are here today.
Sure.
But you touched on it a little bit. Can you speak maybe more specifically to how, whether it's the bail or the discovery, which I know doesn't get as much maybe coverage.
Sure.
But it certainly is a big part of this for folks who work in the criminal justice system.
Sure.
How does that affect, how do these changes, have you seen yet how they impact your officers as to how they police in the community?
Well, I would tell you quality of life issues. I mean, working in a city environment, that's a concern. We all have different, our communities are all different. We deal with different issues, but quality of life concerns, especially unnecessary noise. We'll say noise complaints in a neighborhood. In the past, I mean, the way we usually approach it, you go there, you advise the individuals there's a problem, knock it off. Give them a warning. If there's multiple calls for the same issue, in the past, and again, not a big advocate of it, but there's a time and place, we'll do a custodial arrest. The best course of action we have now is, here's your parents' ticket and we drive away. So the optics on that is pretty bad. A, our community is viewing we're not serving them. B, it limits our options. And then our officers will start looking at why are we going through the efforts, especially on a violation or a lower offense, to even do the paperwork when there's no result.
Thank you. Senator Galloway.
Speaking to the changes in the laws relating to bail, do you have any recommendations?
Well, again, I think it needs to go back into the hands of our judges. I mean, there are guidelines, there have been guidelines in the past. And again, we can all point to abuses in the past, and I don't think a single one of my colleagues is going to say there shouldn't be changes. We need to take a look at it. I mean, how we get there, we'll leave that up to you, but there have to be. Kind of lost my thought there, sorry.
Well, so the change that you would recommend, if it was starting over, is to ensure that the judges have discretion to do their job.
Absolutely. They need the
I don't
full
mean to
discretion,
worry about, but that's what
and
I'm
it should be offense-related, too. They need to be able to take a look at the offense. Everything, especially in the criminal justice system, not everything's black and white. There's a lot of gray areas sometimes. And so they need to have the ability to take a look at someone's past criminal history. And again, it's very specific to your community. And what's in your community most times should be engaged, and they kind of shape and form policing, as they should.
So the judge's discretion as it relates to public safety,
Absolutely.
depending on the circumstances?
Absolutely.
Okay, thanks.
Needs to be able to look at the crime, look at the individual, and make that determination.
Thanks. Robbie?
One more question, Chief, and I should have asked this of the previous sheriffs, and I apologize that I didn't, because I want to ask this of most of the sheriffs today, or law enforcement professionals. One of the example that really was used as an impetus that was brought up a lot last year was the issue of the young man who was in prison in Rikers Island awaiting his arraignment.
Sure.
And I think it was Khalil Browder was the name for stealing a backpack or a knapsack. And he sat in Rikers for several months, almost a year, I believe, awaiting his arraignment date, right?
Sure.
Can you think or recount any situation in your community where that happened to an individual, that they sat in a holding center for months on end awaiting arraignment?
I'm not aware of any. I think that would be a better question for the sheriff, but
Sure.
personally, I'm not aware of any.
Okay, thank you.
Sure.
Okay. All right. Thank you very much. And, yes. Oh, I'm
Chief,
sorry. Go ahead.
thanks for your
Yes, sir.
testimony, and as I said, I do live on Long Island, and unfortunately, you're right. Police Commissioner in Nassau County yesterday, not us, Police Commissioner in Nassau County had a press conference with the county executive and said there's a direct correlation between the changes in this law and witness identification that led to this person's death. Now they're getting criticized for it.
Sure.
But in reality, they're coming out and saying, this is a manifestation, this is the real-life application of this law. And we hope certainly that there can be significant modifications that inure to the benefit of everybody with your input. So,
Sure.
thank you for being here.
I think it's key that everybody involved, as Sheriff Quattrone said, we have an honest, open dialogue about it.
Thanks, Chief.
All right. Thank you very much, Chief. Senator Ransenhofer is joining us. Thank you very much. Also, I was remiss in not recognizing Assemblyman Joe Giglio, who's here. Joe, thank you very much for being here with us from way down in my neck of the woods. Next up, we've got Dunkirk Police Chief David Ortolano. Thank you for being here.
Good afternoon. Again, I want to thank you for inviting me here today. I will start off really a little bit about what Senator Gallivan said. I don't think there's anybody in this room that doesn't think that at times there needs to be change and things need to be reviewed. But when we do have change, we have to make sure that it's not to an extreme that it affects public safety of the communities that we serve. In my 35 years in law enforcement, right up through, I was director of our community policing programs. When I was promoted, I took a lot of these programs over. I started a National Night Out program 26 years ago in our community that is still going strong today. Quality of life issues in our neighborhoods is a very, very big thing with myself and our police department. We reach out to our community. We have a lot of community support. We do a lot of programs within our community, and we encourage them. If you see something, say something. Come to us, especially on narcotics issues. We have a drug task force. We have confidential tip lines. I have people that come into my office on a regular basis and leave me information about what's going on in their neighborhoods. Again, quality of life issues in a small community, a small city like ours is paramount. And one of the issues that I have with all of the changes is that we've encouraged our citizens to come forward. We've encouraged them to get involved to make their community a safer place, to have quality of life in our neighborhoods. The narcotics end of it, of what we're running into, as Chief Snellings had talked about, we put 6 months, 8 months, a year sometimes into our investigation when it comes to narcotics investigations. And I don't think there's anybody in this room that'll disagree with me. Narcotics sales destroys communities. It destroys young children, especially lately with opioid and heroin crisis and things of that sort that are going on in all of our communities. We encourage our residents to get involved. We encourage them to be witnesses. We have confidential informants. We spend months doing investigations. We get search warrants. We take our tactical team, we knock a door down, and we take that person out of that neighborhood and we take them to where they can't do that anymore. That's not happening anymore. We have to now mandatorily release them on an appearance ticket, or at the very least, depending on the severity of what they have done, what they've been selling, and how many charges we have against them for criminal sale and criminal possession. At the very least, we can hold them overnight, and they are mandated to be released by the judges the next morning. And again, my issue, everyone's going to talk about a lot of the other issues today. My big issue I'm focusing on today is quality of life again. Disorderly people and drunk and disorderly people that are disrupting a neighborhood, disrupting, I live on a lakefront community. We have a very, very active lakefront community in the summertime with a lot of establishments. If we get drunk and disorderly people, what do we do with them? Normally in a situation like that, for the protection of the establishment they're in or the neighborhood that they're in, we would take them into custody for their safety as well, hold them several hours on bail, maybe release them or let them see the judge, but it removes them from that situation at that point in time. With what we're looking at now, it's an appearance ticket. If we
No
get
cooling
called,
off period.
if we get called, there's no cooling off period. If we get called back to that same establishment 10 minutes later, it's another appearance ticket. Or that same neighborhood where someone is disrupting the quality of life in a neighborhood within our community. And for me, that's an issue, because we've worked very hard in our community to have the support of our citizens who trust in us and know that we're going to be there to do this for them, to give them that quality of life and to be safe and secure in their homes. And by issuing appearance tickets time and time and time again, that just takes that away. I had a local store owner come to me yesterday from one of our grocery stores. We've arrested a person for petty larceny several times already this month. Why do you keep giving him appearance tickets? He keeps coming back in and doing the same thing over and over and over again. Bail, I realize, one of the big issues with the bail is it's because people can't afford bail, and I understand that. But there is also another side to bail, which truly is about securing those that are a danger to public safety or that are a danger to quality of life issues within neighborhoods or within other establishments around our communities.
And to me, that's important to me, that's important to the citizens of our community. I will relay just a couple examples that we've dealt with already this month. We've had 2 high-speed chases within 1 week within our community, which is never heard of. Within the city setting, we very rarely have high-speed chases. We've had 2 in 1 week this month. The one ended with the suspect smashing head-on into one of our patrol cars. We were able to hold him because there was a felony charge of reckless endangerment. The next morning, he went before our city court judge, and our city court judge had his rap sheet. He had just done the same thing in a neighboring community in Erie County the week before and was released and not held. Our city court judge was very angry that she could not take, on a case-by-case basis, the circumstances along with a record in the rap sheet of the person involved, and then make that decision whether this person should be remanded or held on bail or sent to the county jail. It was an automatic release. And I think that's what's important. The judges have to have that discretion. The judges have to be able to look on a case-by-case circumstance as to the record of the person involved, what the circumstances involved, and then be able to say, yes, this person needs to be secure because they are a danger to our community, they are a danger to our neighborhoods, they're a danger to society. And I think that at least has to be put back in some sense into these laws that were changed.
Thank you very much for that recommendation and information. Yeah, I mean, the state of New Jersey, who, you know, the governor likes to hold up as his example. I think he said the world didn't come to an end, were his exact words. But they have a couple of very important things. Number one, judges' discretion in the state of New Jersey. And also they phased their bail reform in over the course of 3 years, not flipping a switch on January 1st. So thank you very much for your testimony. Any questions for the chief? Yes. Yeah.
Chief, in your situation, if someone is brought in and they just punched their neighbor in the nose and broke the nose, it's an A misdemeanor, and if the person then says to the judge, if you let me go, I'm going to go back and I'm going to break his nose again, does the judge still have to let that person go?
Yes, they do. It's an automatic release. We probably would not bring them before the judge, depending on the severity of the assault. If it's only an assault third, they would immediately be released on an appearance ticket.
Okay, even if they told you to your face, if you let me go, I'm going to go back, I'm going to
Yes.
beat the
Yeah.
crap out of him.
Yes, there's nothing, we have no choice but to release them on an appearance ticket.
Okay. Thank you very much. Any other questions for Chief? All right, Dave, thanks for being here.
Thank you.
Next up, Chautauqua County District Attorney Patrick Swanson. Pat, thanks for being here.
Yeah, thank you for having me, Senator. First, thank you for having me. For those of you that don't know, George Borrello is the senator that represents the geography that covers Chautauqua County. As the elected district attorney, I have the obligation to advocate on behalf of what is best for my constituents. Public safety in Chautauqua County is my top priority, and I am participating in this discussion because my aim is to satisfy my obligation as the top law enforcement officer in my home county. While I believe that our bail system could have been improved, what resulted was a law that fails to ensure victims, witnesses, and law-abiding citizens are sufficiently protected. We need a bail statute that is a reasoned effort to find fairness in our criminal justice system, but that also allows our elected judges to utilize their discretion in situations where bail is appropriate. The new law as written does not accomplish those things. Nobody here is going to tell you that New York's criminal justice system was perfect by any metric. There is always room for change and improvement after careful examination. What we are saying is that the sweeping changes to our criminal justice system went too far and are having unintended consequences to victims, witnesses, public safety, and ultimately the administration of justice. We ask our state lawmakers to take a step back, take a look at all aspects of these laws and the impact they are having on our entire state, and listen to all the stakeholders. We should not give short shrift to the concerns of prosecutors and their law enforcement partners. The outcry from prosecutors and law enforcement is not fear-mongering. This claim that we are stirring up fear for some gain is baseless. There is simply no incentive for law enforcement and prosecutors to speak about this other than to fulfill our duties to ensure public safety. We also urge the importance of adequate funding for the implementations of any changes in the law, because without the appropriate resources, these laws will surely fail in many parts of our state. I say this because the discovery changes play hand in hand with what we've seen change in the bail statute. What I suspect you gentlemen are going to see as you travel around the state and hold these hearings, you're going to see and hear from prosecutors that simply don't have the resources to put these changes into place. These offices that I'm speaking of are small. They deal with a lot of cases. They have caseloads for each attorney that are too high to begin with. And we're being asked now to do things faster and on every case. When in many of these places, you will talk to the district attorneys and you will hear from them and they will tell you about open file and how they've shared the entirety of their file with defense counsel in the first place. The changes that took place beginning this year are affecting those prosecutors' offices in a great way. Now, let's talk about bail for a moment. I don't think anyone here is going to tell you that someone should be held in jail because of poverty or other inappropriate reasons. But judges need to be given back their discretion to make proper decisions about who should be held and who should be released. These judges are elected by their communities. They're elected by their communities because of who they are, what they know, and their qualifications. They know their community members. And for those of you that don't know Chautauqua County, we have 31 local courts. 31 judges or magistrates are elected in my county. My staff of 11 attorneys has to cover those 31 courts. But those judges know the people who live there. They know what their citizens want. They consider a number of factors before setting bail, or at least they did. Because today, they cannot consider those factors that they used to consider. They're forced to release people who have multiple convictions and pose a threat to our communities. Adequate funding must be provided for any successful changes to our bail system. If we have a system that is releasing the vast majority of people who are arrested, we must also have a system that includes drug and alcohol abuse evaluations, and this needs to happen in every county. I worked on the Criminal Justice Coordinating Council with the sheriff who was here, who spoke earlier. Chief Snellings was a member of that committee. Chief Orlando was a member of that committee. We worked very hard over the past 5 years to get programming into our jail so that folks that were held pretrial were getting services, were getting treatment, were getting education. Those programs are now so underutilized, they're not worth the money that we're spending on them. Great efforts have been made in a number of communities just like mine to help the people who are being held pretrial. Other states around the country have eliminated cash bail, and the experiences in these states can be instructive. Judges need to be given the tools and the resources to make proper decisions about who should be held and who should be released. 47 states, 47, permit judges to consider public safety in the determination in setting bail. We are not one of those 47. New Jersey recently moved, and Senator Borrello just alluded to their experiment there. Judges there are permitted to use a risk assessment tool that weigh the defendant's criminal history and the charges they face to determine their risk of danger to public safety. This makes sense. Now, what I ask you as you travel around the state and putting together your ideas and gathering thoughts from people who are interested in this system, I ask you to exercise intellectual honesty. Talk to folks about what is it that our communities need, what do we need to make our communities safe, because as we rolled into this year, New York State was the safest large state in the country, and we had the lowest incarceration rate of any large state. Something was going right here. We've changed that something. I ask you to push your colleagues in the Senate and the Assembly and make responsible change to these laws that were passed in haste and without hearing from all sides. Thank you.
Thank you very much. Appreciate it. Thank you. Thank you. All right, any questions? Yes, Senator Ort.
Yes, Mr. DA, thank you very much for being here. With regard to discovery, because I know that obviously greatly impacts the district attorneys specifically, as well as downstream to our folks, our patrol officers and that. But can you speak to, before in New York, we know that, there was a lot of, under the law, you could withhold certain information for a long time, right? Even exceeding federal standards.
Sure.
Now we've gone, in my view, completely the other direction where you have very little time, 15 days for just about everything. Is there a conceptual, I'm not asking you to negotiate here at the microphone, but is there a time frame that, in your mind, as a prosecutor, or is there a concept that you think would make a lot more sense as far as improving the old statute, but not completely overturning the system like we've done?
Yeah, there is. 15 days, obviously, I think from most of the prosecutors you'll talk to, is a period that is far too short. The policy in my office has always been, we have an open file. So we're sharing information with defense counsel on all of our cases without limit, absent the grand jury minutes, which were protected up until January 1st. A period of time that would be reasonable, and this was an idea that I just given by a colleague of mine sitting in this room. But the 30-30 time, if there's a limit that would make sense, it would be half of that 30-30 time. So you have, a misdemeanor 90 days. A 45-day period to get all of that information over would be reasonable. Even 30 would be reasonable. But 15 days is a short amount of time because it's not just as simple as my office going through all of that information, redacting the appropriate information that needs to come out of the file. But that includes the police department putting that file together. And on some calls, you have a half dozen or more police officers arriving, which all have body camera footage, which all have to sit down and compile notes. And life gets in the way, too. You have a police officer that shows up to a scene, and 2 days later they have a vacation scheduled. That happens. But that 15-day window is too small. And I'm not saying that you couldn't craft a window that's large enough. It's just the window that we were given, 15 days, is so short for the police to get all of that information to us to review it, and to get it out. What we've seen here over the first month in my office is we're running as fast as we can to keep up. And it's like we're on that treadmill that's going a little too fast. At some point, we're coming off the backside of it. And I worry about that day.
Sure.
But no, there is a time frame that would be realistic.
More reasonable.
But it's at least 30 days. I mean, it's just 15 days is too short.
And last, I'll repeat the question, the Khalil Browder situation, the young man who was in Rikers Island. Are you aware as a district attorney, and I'm not, maybe you're not, but are you aware of any situation in your county where somebody sat in the county jail for months on end awaiting an arraignment?
No.
Thank you.
Thank you, Ray. Senator Ransome?
Yeah, thank you. I want to ask you about the turning over of witnesses' names and addresses. And I was sharing with my colleagues earlier this week, sometimes art mirrors life, and sometimes life mirrors art. So I was sharing with my colleagues, and I was watching Blue Bloods, a television show, a popular television show, and one of the scenes there is you have the Tom Selleck, who's the police commissioner, and you have his daughter, Bridget Monahan, I think, who's the DA, and they had to share, someone was arrested, and they had to turn over the name and the address of the witness to the person's lawyer, who shared it with her client, who then shared it with her brother, and then they beat the crap out of the witness. And just I think it was yesterday or today, there was a situation down on Long Island where there was a release of a witness's name and address, or release of witness information, and that witness was killed. So, and you didn't have this before the new law. You wouldn't have that situation. So, again, I don't know whether it's art imitating life or life imitating art. But how do you, and the public is going to see this. The public is going to see, hey, a witness who was cooperating with the police was killed because their name and their information now had to be released. What are you, as a DA, going to do about that to make sure that one of your witnesses is not killed while at the same time fulfilling your statutory obligation of now having to turn over this information?
Well, what the new law creates is, I guess I don't want to use the word opportunity, but the opportunity for a lot more litigation. And we would have to litigate that. If we're going to protect a witness, it's one witness at a time, one protective order at a time, filing those motions in our county court, seeking to redact information about the witness we want to protect. They're real issues. I mean, I think the example in Long Island is not going to be the only one like that. And I don't say that in jest. I don't say it in, lightly. This is a serious thing, but it's not going to be the last example like that. The new law does create some problems, and you heard Chief Snelling talk about, those folks that call in a neighborhood complaint because they have drug activity in the house next door. And right now, or up until 2020, those people were calling in an anonymous complaint. Those days are over. What you will see here is the information from that call will be recorded. That information and contact information will be passed on if arrest results. And those people that, want to just make sure their neighborhood's safe, their name's going to be exposed in a way that isn't known to them. Because up until January 1st, we were able to tell witnesses, we can protect your identification if and until there's a trial, which means almost all cases, because a large majority of cases would result in a plea, which means that the information from that concerned neighbor who's calling in drug activity next door would be held in our file if we wanted to protect them until it went to trial. And that's an important part of our criminal justice system, because otherwise people don't cooperate. And what we're going to see as we move further and further into this year, as the public becomes more and more aware of what this law, the exposure they're going to see under this law, we will see less cooperation. And that makes prosecuting cases more difficult. And as I said in my very first paragraph of my statement, it's going to affect our ability to administer justice.
Let me just follow up, because, so if you take your county, okay, you're one of 62 counties in a smaller county. So as a DA, you would have to be right 100% of the time. I mean, you have to make a determination, well, do I go to court? Well, let's say you have 10, 20, 30,000 cases across the state, and you say, well, maybe on this one I don't, and you're wrong. I mean, how do you deal with that? How can you assure the public that, when this person's identity is released, that they're not going to be intimidated, they're not going to be beat up, and as we saw recently, they're not going to be killed in order for someone who's accused of a crime. If they can kill the witness, they're not going to be, they're not going to be convicted. I mean, how do you deal with that?
We can't. We can't assure them that. We had to develop a form, essentially, a form letter that we will send to all of our witnesses and our victims that essentially tells them, look, given the new statute, here are the possibilities. We can attempt to protect your identification by seeking a protective order. We may be granted that protective order. If we're not, you may be contacted, because we have to provide your contact information to the defense lawyer. You could be contacted by them, and then we advise them, it's up to you whether you want to talk to them or not. And that's how it's...
Contact is fine. I mean, how do you protect yourself from getting beat up, shot, killed, stabbed? I mean, I don't think a witness would object to being contacted. Sure, you want to contact me? Maybe I'll talk to you. Maybe I won't talk to you. But how do you deal with someone that comes in with a gun or a baseball bat? They don't want to talk to you.
Right.
They want to silence you in order to protect themselves.
Yeah, we do not have the ability to provide that kind of protection for a witness. We just don't. We can advise them of all the possibilities moving forward, but the best we can do is tell them what the process requires. And if they see anything out of the ordinary, contact law enforcement officials. But we have been advising our witnesses and our victims of the changes.
Thank you. Oh, go, sure.
Steve, I thank you for your testimony. I'd love to see that letter. The letter you said you're sending to, I think that would be helpful. You can give that to Senator Borrello. Senator Ransonoff made an important distinction. We're talking about smaller counties, and yet the issues remain the same no matter what the venue. City of New York, Mayor de Blasio said that they had to spend, they put $175 million in their budget. Of course, they got a nickel. They didn't get a nickel for any of it. And I was talking to an Erie County legislator a couple of weeks ago who said they had to hire, I think, 18 new ADAs. Two-part question. Have you had to do something like that? And how do you even find the money? Because I know you have other limitations. So, and the balance that I'm looking for is, does your staff in your office feel like you're coming up against it? My resources are strained to begin with. Now, some cases are just gonna go by the boards, no matter what we try to do, because we don't have the requisite resources. Is that a generally fair description?
Yeah, I'm gonna probably break that up into three different parts. And the starting part, and I think Mr. Burrell knows this, being our former county executive, we have a relatively poor county. We have a budget that's strained and stretched. And in addition to that, my office carries the largest caseload per prosecutor of any of the 62 counties in New York State. They were generous enough to find me the money in the budget to add a prosecutor this year. I suspect we'll still be in the bottom 3 of the highest caseloads in the state, but you know, the reality for us in Chautauqua County is, as a prosecutor's office, is, you know, we are fighting with not enough resources on a daily basis. And you know, our public defender's office gets a lot of money, and they probably need it. But their budget this year is $4.5 million, and mine is 2.3. And we prosecute every single case. We do our own appeals, and they handle 95% of our calendar, and they don't do appeals. So our public defender's office is almost double what mine is to do the same job, or if not less. So my county is struggling with staffing and trying to find out. Yes, Senator Gallivan, that was accurate data. It's frustrating at times, but I'm fortunate to have a very good staff who cares a lot about what they do.
Thank you.
Thank you. Thank you again for being here. Appreciate it. If not, we'll move on to the next speaker. And Pat, thank you very much. We have Christine Morseman, Allegheny County Probation Department, Senior Probation Assistant and Pretrial Release Coordinator. Christine, thank you very much for being here. We appreciate it.
Thank you for having me. I think I come from a little bit of a different perspective than the sheriffs and the DAs, because I kind of consider myself as a neutral party when it comes to this, as a pretrial release coordinator. And pretrial release was established in 1980s to help level the playing field when it came to cash bail. If you had somebody that could not afford bail, they're seen within 24 hours, interviewed, and we assess their eligibility for pretrial release. And I can confidently sit here and say in my 28 and a half years of doing this job in Allegheny County, not one person has languished in our jail pre-trial for an extended period of time. And we are the 3rd poorest county in New York State, and we have 0 resources. We do not have an inpatient treatment facility in our county. We don't have inpatient mental health. We don't have a full-time psychiatrist in our county. Our public transportation is sparse and limited, and in most areas, it doesn't even reach those areas. But when we get involved with people at that pretrial level, because they've been arraigned and sent to jail, we provide the court with what they need to assess a safe release of somebody in the community, and we monitor them, we supervise them, we set up the supports. We use R&R, their risk, needs, and our responsivity to what they need. Not blindly enacting something that puts people out on the street on appearance tickets. And recently, in my town of Bolivar, New York, where there's only a population of like 954 people, and there's 953 today, and they'll know that I'm not there. But we had a man up the street who had induced psychosis from the use of methamphetamines. He went to the upstairs apartment, broke in, trashed the apartment, took a hatchet to the furniture, stole the truck and weapons, led the police on a high-speed chase from our county into Cattaraugus County, multiple violations, felonies, and he was given an appearance ticket. He came back to his home, and because we are familiar with him in our department, his son called and reached out, said, is he on pretrial release? Because he couldn't figure out why he was home. because I haven't been able to reach him. I know he was released. No, but we were familiar with him, so we reached out to see what was going on. And in the time that he was released, he was back at the neighbor's door that he just victimized, pounding on the door with a billy club, cut his cable to a satellite dish. We knew there was mental health underlying, not just from the meth, so we reached out to our mental health people. We have limited resources. They did go pick him up, take him for evaluation in another county, because we don't have anything in our county. He was released, went back home. That night, shot himself in the head with a staple gun. Then he was admitted to the psychiatric care unit. But he was also arrested December 24th for a burglary in another town. He was in jail on December 24th. I know the holiday came. But right immediately after that, Christmas, he was interviewed for pretrial release before the new bail reform. And we were in the process of assessing his mental health needs, his substance abuse needs, to release him door to door to a dual diagnosis facility in Bradford, Pennsylvania, because we don't have anything in our area. But the first of the year came, and he was released, and he committed that offense that I just described to you after that. We have worked tirelessly in our small county. I am the only pretrial release coordinator. I know we're small. I know larger areas have more people, but it's just me. We don't have social workers. I'm in the jail every morning. I take a look and assess their needs, whether it's education, employment. We don't have a homeless shelter. We have homeless people. We have to get creative to find placement for these people. I might be on the opposite end of the spectrum, even with my husband, who is a lieutenant at the sheriff's department. Lock them up, I get them out. But we've come to, I guess, an understanding that not everybody needs to be in jail. And the people that are not released through pretrial are the people that need to remain there. And it's true. And we were also victims. 11 years ago, this January, my daughter's 13th birthday, we had a new puppy. We were terrorized for 45 minutes by a person who had substance abuse issues, trying to break into our home, threatening to slit all of our throats. Of course, my husband's law enforcement. He wanted to go outside. And I said, what happens if something happens to you? We have young children. I'm in the home, then what? Stay here. We called for the state police. And in our county, we don't have all the villages and towns. Most of them don't have police agencies. The ones that do, they're not full-time. We have 2 cars from the state police that covered the entire county that night. It took him 45 minutes to get to our residence. When he tried to enter our house through 3 different doors, he actually had a shopping cart that he rammed into our front door. Then he punched all the windows out of our garage. At that time, he could go to jail. He did go to jail. In our department, he was released. I didn't do the interview, of course. My director had to. Under pretrial supervision with electronic monitoring, which under this new bail reform, we can't use electronic monitoring anymore. He was ultimately sentenced to probation, violated that, ended up going to state prison, came back out, and has had a life of crime ever since, and now is currently in jail on a misdemeanor probation violation. That's the only thing that's keeping him here, but he's also being held on charges of criminally negligent homicide for selling heroin that killed a young mother in our town. Absent that violation of probation, he would be back out on the street. Do we need bail reform? Yes. Have we seen judges sometimes set excessive bail for misdemeanors? Absolutely. But that's the beauty of pretrial release. I'm there. We take a look at it. They're released most of the time within 24 hours. Some have to detox there. We don't have detox facilities, so they might stay there a little bit longer. But I make it my mission to find what they need. And what's risky for one person is not risky for the next. What the needs of one person is not the needs of another person. And this law doesn't allow us to take into account what the person's risk and needs are and how we can respond to that effectively and safely for the community. And it's extremely frustrating for us. That's basically it. I mean, I can give you, since the first of the year, DWI, felony DWI, appearance ticket. the man that was issued an appearance ticket has a criminal history dating back from 1978 from Tulsa, Oklahoma, where he had robbery, several DWI convictions, burglary, escape in Oklahoma, came to New York State probably around 1993. 2009, aggravated cruelty to animals, shot and killed their family dog in front of his children and had menacing charges. He has burglary 2011 through 2012, 6 burglary charges, 3 grand larceny, 2014 DWI, 2016 burglary conspiracy, 2017 DWI, 2018 DWI, and on February 2nd, 2020, was issued an appearance ticket for a felony DWI with no supports because we didn't have an opportunity to meet with him. I will say there were some judges that recently, we have a young man with some mental health making terroristic threats. He could have come to jail, but they chose, because we work closely with our local magistrates and our county court judges, to offer pretrial release from the bench for people. And that's what happened. He was released under our supervision, told to report to us the next day. We take a look and assess what his needs are. There are people that can change, and we can impact on them when they're in crisis mode, not when you're just issued an appearance ticket where there aren't consequences, and consequences sometimes equal motivation to change, and that's thrown out the window.
Thank you very much. Any questions from the senator? I'd also like to welcome Senator Chris Jacobs. Thank you very much for being here. Any questions?
You answered my question right at the end with a couple of your statements, but I think you present an interesting perspective. So, of course, we don't, and you don't, want to see people discriminated against for economic reasons or any other reason.
Absolutely not.
But the pretrial services, they came about for a very important reason, to help prevent some of that, to help mitigate that, to keep people out of prison who haven't been convicted.
Correct.
Yet, you're addressing a number of things. Public safety matters, and trying to provide some supports to the individual that change the ultimate behavior so they don't reoffend.
Absolutely.
And this law does not provide for that.
No. And we have cognitive behavior intervention programs that we use to teach. We have what we call Thinking for a Change, and we have what we call CBISA, which is Cognitive Behavioral Intervention for Substance Abuse Users, that they report to class twice a week. Even people that were on pretrial, it gives them an opportunity to, get their ducks in a row, make some changes before they stand before the court for sentencing. And we've had sentences reduced, we've had charges reduced, we've had people that maybe were arrested because it was a substance-induced psychosis, but now they've gotten treatment. We've seen charges be dismissed because that person didn't have an extensive criminal history, but because of maybe trauma, something that happened in their life, they ended up in the criminal justice field. That's not everybody. There are some people that do need to be incarcerated for public safety, but we can assess that through the pretrial release program.
Thank you.
And one more thing on
Yes,
bail.
please.
The statute allows for sentencing. There's parameters for sentencing. If somebody commits, e-felony, maybe it's 1/3 to 3 years. It's that simple with bail. Set the statutes. If it's A misdemeanors, then the bail is this amount and not more than this amount. If it's A felony, it's this amount and this amount. Simple fix.
Thank you very much, and thanks
Thank
for
you.
coming down from way up in Allegheny County. Next on our list is Jay Giselle from the Genesee County Manager. Thank you.
Thank you, Senator.
Thank you.
Pardon me for reading a little bit much. This is not, like my colleagues in blue and black, this is not my daily profession, but I've been doing this 45 years. I'm a native of New Jersey, so anybody who thinks that a New Jersey statute is something to follow really is not in a good position. Again, from the perspective of county government and from NISAC, which is the State Association of Counties, first, again, like I said, I'd like to thank you folks for holding these hearings. This was not done, and I went to a couple press conferences in the center of the state and downstate, and even in Rochester 2 months ago, before the law itself came into play. The DAs, the public defenders, even also the law enforcement personnel, all were basically ignored as this law was actually being trotted out and put together. And so part of what I put here today is for you, some things you asked for, some suggestions. So we start right off with give judges the discretion to impose bail when appropriate for all criminal activity enumerated in the statute. Increase the discovery timeline from 15 days to 45 days. Phase in discovery reform by applying these new mandates only to misdemeanors effective April of this year, and then do the felonies in January of 2021, and repeal the provision that makes the new discovery mandates applicable to violations of the vehicle and traffic law. Require that court appearances reminders are sent not only to the defendants, but also to the victims of their crimes. Extend appropriate dignity, fairness, respect to the crime victims by soliciting input from victims advocate organizations and, considering also the suggestions for improvements to these laws in general. The law as presently written restricts judges' ability to set bail in only the most violent cases, not based on a suspect's criminal history, flight risk, or their potential proclivity to commit additional crimes when released on an appearance ticket. This is one of the areas where, again, the New Jersey statute, my home state, differs from the New York bail reform law as it was written. And if the New Jersey statute is a model for New York statute, then that really needs to be corrected. Presently, also electronic monitoring is all but null and void as far as this new statute is concerned, based on the inordinately narrow constraints of how you can actually procure and utilize those resources as far as vendors are concerned. Harassment 2 is a domestic violence offense arrest that is now a mandatory appearance ticket and release dictate. This seems to have slipped through the cracks under the overly aggressive and hastily written, yet in place, January 2020 statute. Witness information, data accumulated on all potential witnesses is too heavy a burden. Identifying such as a broad universe of potential witnesses is a burden that the defense itself needs to take commiserate responsibility for when mounting an adequate and effective defense, as in the Gideon versus Wainwright statute that started all this back in the 1960s. P.S., as was mentioned before, in Genesee County, our public defender's office, with the new indigent defense guidelines and the enhanced ILS funding, is slated to receive $5.8 million over the next 5 years to begin to, which is basically doubling their entire appropriation and the size of their fiscal capacity, to represent effectively and this is occurring across the whole state. So understand that the ILS funding, with Harold Herring and other things, has exponentially expanded what public defender offices are doing. Therefore, the issue of whether or not there is a delay and/or deferral and denial with regard to in the court system cannot be something that you can lay at the feet of the understaffed public defender's office. As was mentioned, our public defender's office will now be almost double the size of our DA's office on an average daily basis, both in terms of attorneys and support staff. Also, the court orders for access to crime scene. This is something that, again, was on a statewide basis, our NISAC Association has looked at in terms of potential Fourth and Sixth Amendment, U.S. constitutional amendment violations that the courts cannot obviate, and the notice requirement is also not accompanied by a right to private counsel. Again, this is kind of getting into the weeds, but this is what my people are telling me in terms of, as an administrative officer, what they're trying to deal with. Again, to the end, Governor Cuomo has indicated that bail reform should be a cost-neutral proposition for counties, if not savings, due to the reduced jail population. I respond that no two counties are the same, that our courts and our incarceration facilities are also not the same. They are not a cookie cutter, nor is the criminal and community activity of such criminals the same in any kind of cookie cutter approach in the way that this statute was seemingly put together. And again, that means whether you're rural like we are, suburban, or even obviously urban as we are here in Erie County and our other neighbor, Genesee County. In the budget that we just put together in Genesee County for 2020, there's $250,000 just on the bail reform new costs in our budget, which is about 7% on the tax rate, which is basically our tax cap. So if we exceed the tax cap, we are then in a lot of trouble with the gentleman at the second floor of Albany with regard to other restraints and constrictions that will occur in our budget if we exceed the tax cap. So again, with expedited both discovery, and bail reform, this, in our little county jail of 99 people, which is all males, we cannot hold females because we don't have the space, nor do we have, even with the bail reform and the new reduction in population, we are under significant constraints at the Commission of Corrections to improve our incarceration facilities. All of our females right now are being boarded out and have been for the last 25 years. We've never had a female in the time that I've been there in 25 years in our county jail, but finally we have 3 corrections officers who are female. So again, in that regard, we are looking at, as far as since January 1st, actually in December, about a 40% reduction in our average daily male population and about a 25% reduction, respectively, in our female population. But again, we're taking them as far away as Allegheny and Steuben County in some cases. But again, that is not giving us any relief with the Commission of Corrections because of staffing and the way the space is actually is built, but also in terms of the care and custody of the inmates, the detainees, the principals, I think as they're called, under this new statute, and actually under existing incarceration activity with regard to any potential lawsuits, or also obviously them making their they're being able to appear in court on a regular basis. So, we are also in the throes of looking at and trying to design a new county jail, which could be upwards of 186 inmates, potential cells. We put them in pods. We're developing a plan of about $60 million. And one thing that you folks might be able to do for us is the one good thing that I saw in this budget that the governor put together was the option for counties potentially to go together and put together a jail incarceration facility, small counties like ours, and in the case of our neighbors to the north, Orleans County. That was a suggestion. It's been something that others have looked at. It's not really popular, obviously, with my colleagues in law enforcement per se, because that is one of the two things they are obligated to do, which is provide warrant service, civil service, and also jails. But again, for small counties like ours that are under significant constraints with, in our case, a 100-year-old facility, obviously building a new jail is something that is on our horizon very quickly, very soon, not something we can keep delay or deferring. And so, to that end, and that's all 100% county cost. There's no grants, there's no aid, there's no new era money that's coming out of the state of New York nor the federal government to help us pay for that. Finally, the singular advantage also that Genesee County also represents is that we have a strong and trusted pretrial program of 30-plus years, along with an alternative to incarceration approach that is, ingrained in the court system across the county, at the magistrate level, at the city level, at the county court level, state judge level, and has never been propagated with the idea that we merely send people to jail to teach them a lesson. Bail reform is not a panacea for county incarceration savings versus the new mandates in expedited justice and bail reform. Also consider the overarching aspects of equal justice in the interest of criminality versus the victims and the overall community safety and security, and what services, life-altering options the non-murdering, non-terrorist, felonious suspects can or will avail themselves if they're just out on an appearance ticket versus that we are dealing with them in our pretrial programs or in terms of literally the most egregious activity in terms of being in a jail, which is what we've been doing for the whole 25 years I've been there and even before that. And we do not think that just the mere appearance ticket is going to institute those kind of abilities to reach out and make changes in people's lives so that their consistent criminality maybe and the threat therein is broken. And as I indicated that in my statement here also, that when you have 41 different felony and misdemeanor charges that now under bail reform basically end up in just going out and saying, get an appearance ticket. Again, this legislation was both seemingly hastily put together, but also without disregard as to that local discretion as far as the jurists are concerned, the magistrates and the judges themselves. Thank you.
Thank you very much for running through all that very quickly, as a matter of fact. I might add, thank you so much.
When you're oldest of five from Jersey, you speak fast.
Yeah, exactly. That's the benefit of being from New Jersey. Any questions for the county manager? Yes.
How much is it costing your county to hire additional staff or attorneys in the DA's office? And between the DA, the Sheriff's Department, and even the Probation Department, it's about $250,000 just this first year, Mike, and just the first to get ready as of January 1st of 2020 to gear up just for the expedited discovery, and then obviously what that represents in terms of trying to get into a court system within 15 days, which is not 15 days. Law enforcement is being told 3 or 4 days, you got to get all this information together. Body camera information, all the witness statements, the reports themselves that the officers are making, they don't have 15 days because the DA and getting things to the public defender's office and to the defense is certainly has to be much more aggressive to meet the 15-day requirement of the statute. And the exceptions granted for the judge potentially to even defer and delay that are almost non-existent. That's just our little county.
Yeah. Just one quick question, and I think you may have covered this, but I may have missed it. You're currently at minimum staffing levels in your jail?
Yes.
Okay, so again, no savings there because
No.
from that standpoint.
No, and again, we have a 3-story, 100-year-old facility, has basically blocks and cells, and it was built for a whole different time and a whole different mentality as far as criminality, but also community corrections. It is not something that we are necessarily proud of, but it is what we are working with. Therefore, the commission comes in now every 6 months and evaluates whether or not we get to keep even operating as a county jail versus telling us send everybody to, like all our females, send them all to someplace else in Western New York. like I said, literally, we're down to Allegheny, Steuben, in some cases even into the Syracuse area on a daily basis with the females that we are presently dealing with.
Okay, great. Well, thank you very much. Anybody else? Chris, yeah.
One quick question, your recommendation number 3, that repeal the provisions, discovery mandate for vehicle and traffic law.
Yeah, there's a whole section of, there's an actual statement, I have it here, and it's in, I think it's on, it's in one of the other pieces of information that our National State Association of Counties put out. There's actually language that's in the present law that is being recommended to be changed, and there's 2 or 3 sentences that talk about what the VMT law should be under the new statute, not the way it's presently written today, if there's an opportunity for reform.
In fact, I was at New York State Association of Counties last year when I was still a county executive, and we had a presentation from a DA downstate.
Yeah.
And he said, I will never pay a traffic ticket ever
Yeah.
again in the state of New York, thanks to
It was the
this
Nassau
discovery
County
law.
DA, I
Yeah,
heard the same statement.
Yes,
It
yeah.
was quite revelatory when you think about this, as the gentleman from Chautauqua County said, when you're the chief law enforcement officer, and those are the kind of things that are running around in your average daily activity, but also the thinking process of your prosecutorial office, that's not good public safety, and it's not good criminal justice, plain and simple.
Yeah, great. Agreed. Anything else? All right, thank you very much.
Thank you.
Okay, now we have up Kevin Stadelmeyer. He's the Chief Attorney for the Criminal Defense Unit for the Legal Aid Bureau of Buffalo. Thank you for joining us.
Thank you very much, Senator. Allow me, if you will, to provide a bit of a counterpoint here.
Please.
Obviously, we've heard from law enforcement, and we've heard a lot of the things they've had to say, but I'm a public defender, and maybe not everyone's going to like what I have to say, but I'm going to say it anyway. I'm also here speaking on behalf of the New York State Criminal Defense Association of Criminal Defense Lawyers, as well as the Chief Defenders Association of New York. And as an initial matter, bail reform has been a godsend for thousands of low-level, nonviolent offenders in New York. Our clients are no longer losing their jobs, they're not losing their housing, their cars, their children, while they languish in pretrial custody. And it's an economic and social win across the board. However, unfortunately, there's been a robust disinformation campaign on the new reforms, led primarily by Senate and Assembly Republicans. And the reasons for that aren't all that complex and have very little to do with public safety, and I'll get to that in a little bit. And we've heard 2 of them already today. We heard about the murder down in Long Island, the MS-13 murder, where it was initially linked to the new reforms. Well, about 12 hours ago, the commissioner down there, Commissioner Ryder, came out and said, we were wrong, it had absolutely nothing to do with the reforms, we're sorry. You guys are still touting it as something to do with the reforms. And Senator Ransenhofer, you asked earlier of District Attorney Swanson, some neighbor goes over and punches a guy in the face and breaks his nose, does he get out? He does not get out. That's a violent felony. That's an assault second.
He's charged with assault third.
Well, we could talk about assault third, but in your example, assault second, broken nose, serious physical injury, that guy goes to jail.
Broken noses are very often charged as assault.
Well, I tend to disagree being in court a little bit more. But in any event, let me address some of the disinformation that you guys are hearing. First, we're hearing that we're allowing dangerous criminals out on the streets and that crime is rampant throughout New York State. What's the truth? Well, we really don't know yet, because no amount of statistical analysis is going to show whether crime is actually increasing or decreasing since January 1st. The law's only been in effect for 37 days. The New York State Department of Criminal Justice Services, which is the foremost authority on crime stats in New York State, doesn't even have verified statistics from 2019 yet, let alone 2020 in January. All evidence of rampant crime at this point is anecdotal at best and a gross exaggeration at worst. And of course, despite all the talking points coming out, not all crime is attributable to bail reform. There was crime before bail reform, there'll be crime after bail reform. And let's be real honest, very little of the previous bail law was about keeping dangerous people in custody anyway. Any offender of means, any offender who could pay the bail was allowed the release. If they could pay the bail set, they could get out, regardless of the offense. Weapons offenders, sex offenders, robbers, burglars, DWI manslaughter offenders, all of them, if they could pay the bond, they could be released. So we see this as far less about dangerousness as it is about criminalizing impoverished and minority populations, and the new law restricting the criminal justice system's ability to do that. And in terms of whether it was expected that the new law would cause any increase in the crime rate, let's look to the law enforcement experts in our own backyard, and let's look to Erie County District Attorney John Flynn. DA Flynn, as early as March of 2019, stopped asking for cash bail on violations, misdemeanors, and nonviolent felonies. He clearly felt there was no increased risk to public safety or for return to court rates rising. He knew that the positives of a progressive position on bail far outweighed the negatives, and if we're not going to listen to the top law enforcement official in Erie County, who really should we be listening to? Now let's get to the core of what the new law is designed to do. Since its inception, the purpose of bail, as stated in the previous statute as well as the new one, was to secure a person's appearance in court. That's the stated purpose of bail, period. However, the pre-January 1st law was regularly, systematically, and purposefully hijacked for far more nefarious purposes, to maintain control over minority and impoverished populations, to coerce guilty pleas from clients desperate not to be held in jail pre-trial, and to enrich an antiquated, predatory, and abusive bail bonds industry. And we changed the law to deal with these abuses. These were the negative effects of the previous system, and they have largely been rectified by the new reforms. And on the issue of returning to court, even though it's very early, I do have some statistics. The Legal Aid Bureau of Buffalo, where I work, we have about 60% of the criminal cases that are heard in Buffalo City Court. For the entirety of 2019, bench warrants were issued on 4.5% of our criminal appearances. In January of 2019, a year ago, that was 4.6%. I think this is going to echo some of what Sheriff Howard said. Now, according to the disinformation campaign, this new reform should have resulted in a tremendous rise in this number. We should be seeing skyrocketing bench warrant rates across the state and in Buffalo. Instead, for the first 36 days of 2020, we've seen a bench warrant percentage of 4.1%. So we're seeing the rate dropping from one year to the next and from 1 month over the course of last year. So this is another positive. And again, I don't want to tout statistics. It's very early. But I like this statistic. And this was something also highlighted by Sheriff Howard, who sees this as a negative. I don't see it at all as a negative. 229. Now that's the decrease in the number of inmates that were held in the Erie County Jail between August 1st and January 24th of this year. August 1st of 19, January 24th of 20. That's a percentage decrease of 26%. That's 229 people who aren't losing their jobs, who aren't losing their housing, who aren't losing their children, who aren't costing hundreds of dollars a day to be held in county facilities, and who aren't being forced to take damaging plea deals to get back to their families, and who didn't have to waste precious and limited resources to pay a bondsman to be released. 229 people, 26% less. That's a compelling statistic. But forgive me and respectfully, this is the statistic that really matters, and I'm sorry. 33 and 10. That's the number of seats you guys need to flip the Assembly and the Senate for next year. And that's why this is driving your disinformation campaign. Now, you guys may have seen this great movie. I love it. It's The American President. You guys seen it? It's terrific. Michael Douglas plays a president, and towards the end of that movie, he gives a speech, and he's talking about his opponent. And what he says of his opponent is that he's about two things, and two things only: making you afraid of it and telling you who's to blame for it. And that's how you win elections. And I'm sorry, that's what this is about, because it isn't about public safety. Republicans and law enforcement, citing 5 or 6 sensationalized stories out of literally thousands of cases, are trying to make the case that we should be afraid of poor people and minorities charged with overwhelmingly low-level, nonviolent offenses, as well as highlighting a fictionalized, escalating crime rate without any statistically significant support. And they're blaming Senate and Assembly Democrats for being progressive and brave enough to finally address the inequities and abuses in the old system. And they're actively campaigning on this issue. Senator Flanagan, who's not sitting in the room right now, said as much recently. It's the #1 issue, and it's not even close. It's what everyone's talking about. Well, why is it the #1 issue? Well, it's the #1 issue. It's because it's the one you guys can use to generate the most fear. You figure making people afraid of poor people and minorities and using progressive bail reform as a lever is going to be enough to swing the vote. Please don't buy it. In closing the new reforms, the playing field is leveled. Our clients aren't losing their jobs. They're not losing their housing, their children, all because they don't have the means to bribe the system to be released. And no longer will the courts and prosecutors be able to leverage further pretrial incarceration in an effort to extract quick dispositions. And no longer will we be wasting millions of dollars, taxpayer dollars, on incarcerating low-level offenders when there's no earthly reason for them to be incarcerated in the first place. This is a huge positive for the state of New York, socially, economically, and equitably. And I'm sorry, no amount of Monday morning quarterbacking by law enforcement or Republicans are going to change that fact. And we cannot go back. Thank you.
Thank you very much. Folks, if you have some questions.
Thank you very much for your testimony.
Thank you, Senator.
Appreciate you being here.
Thank you.
Unlike our colleagues on the other side of the aisle, we actually are inviting and have people speaking here that are presenting an opposing view. So I appreciate that you do have an opposing view. So I want to ask you a question before I open it up to the other senators.
Yes, sir.
And I understand that, bail could be excessive at times, but also judges used to have the discretion to hold someone without bail. So it really doesn't matter money-wise how much you have. If the judge felt that you were a danger to yourself or society, or you were a flight risk, because again, this is all about bringing people back to court. You said that, right?
Yes, sir.
To face there. So how do you then eliminate that and take judge discretion away to hold somebody? Just explain to me your thoughts on that.
So I think when you give judges discretion, as it had been in the previous system, you open it up to a wide range of abuses. You open it up to their own personal subjective view of what a client is all about. And frankly speaking, giving judges discretion for as many years as they did created the inequitable racist system that we saw. You allow judges to use their own judgment or their own biases, their own experiences in setting bail without very much limitation whatsoever. There was very little limitation on judges setting bail. The only limitation was us fighting hard against it or running over to Superior Court to try and convince another judge to let that person out of jail when an unreasonable bail was set. A very difficult proposition. So without rules in place, without guidelines in place, which never existed prior to January 1st, you're relying on a judge to be reasonable. You're relying on them to not use subjective measures and not use their own biases or their own personal reasons for setting bail. You can't go back to that system. It's what created the problem in the first place, respectfully.
All right, and Senator Galvin, you have a question?
I'm sorry I missed your testimony. And,
It's okay, Senator.
you may have covered this.
Thank you.
What are your thoughts about a risk assessment tool, if it can be one that could be used that is non-biased and truly objective, to be used as a tool for the judges, like we see in some states, including New Jersey?
So respectfully, Senator, I'm not a social scientist, so I haven't studied in-depth risk assessments. But by and large, I have, the things I have read, the things I have heard, is that it's almost impossible to create a non-biased risk assessment tool. If there's a study that's done, if a risk assessment tool comes out that people talk about using, certainly I'm open-minded enough to take a look at it, and if it's something that can be useful, fine. But again, what you're talking about is going back to inserting dangerousness in this whole conversation and giving judges discretion to assess dangerousness, which again led us to all the problems that we had with the bail law prior to January 1st.
Through the use of that subjective, non-biased tool.
You're talking about an objective non-biased. Yes, I'm sorry.
Yeah, I apologize.
Oh, that's okay.
Objective.
My fault. So again, I would look at it, but I'm not confident, and again, not being an expert in the field, I'm not confident that's going to solve the problems that you're talking about.
It can be biased, there's no question about it.
Certainly.
The key is to make sure that the right things are measured and the right questions are asked.
Certainly.
All right, thank you.
You're welcome.
Is there any other questions? Yeah, yes. Senator Ransom.
Yes, thank you. So a couple of questions. You just made some comments that on the bail issue, that because of the judge's personal experiences or the judge's biases, they really can't be trusted or they really shouldn't have the ability to be able to exercise discretion. So I was really intrigued by that. So in the area of sentencing, where judges have discretion, that they can impose like up to a year on misdemeanor, would you then be advocating because of the judge's background or the judge's personal experience or biases that they should have mandatory sentences, that they should not be able to use their discretion? So in other words, if you are convicted of a B misdemeanor and you have 3 prior B misdemeanors, that therefore the judge should not have discretion, they should have to impose whatever the sentences as set by law?
Well, respectfully, Senator, you're talking about two different things. When a person is understood, but when you're incarcerated pre-trial, you are innocent. You are innocent until proven guilty. You are sitting in custody, having been convicted of nothing. So why should we give a judge a discretion to put somebody in jail who's at this point innocent, according to the law, has done nothing, after they've taken a plea, after they've gone to trial, after the judge has heard whatever evidence that they've heard? This person is now found guilty, and now they are subject to penalty. At that point, I have absolutely zero problem with giving judges discretion to determine the proper penalty. Prior to, I have a huge problem with it. It opens it up to tremendous abuses. Now, understood, and your point is well taken. Judges are always going to use their own biases and their own subjective measures when doing sentencing as well. But again, that person is now subject to the full penalties of the criminal justice system. They shouldn't be subject to those penalties prior to being found guilty.
And there's a couple of other questions. So we now have the new bail laws, and obviously dangerousness to the community is not a factor that's taken into consideration.
Correct.
And actually, recently, I think there was a judge who decided on his own to use his discretion.
He did.
To say, well, this person, I feel, is dangerous to the community. You know, we heard from law enforcement today of situations where people are released and then they, you know, go and commit other crimes. And I understand the purpose of bail is to secure return, not to, you know, not to make a determination of guilt or innocence. But what do you say, you know, if the judge is sitting on the bench and it's not one of the covered offenses, and the judge feels, you know, like in the example that I gave, you know, the person, it's a bar fight or whatever, someone gets a broken nose, they're charged with, you know, with third-degree assault, and maybe it should be second, but they're charged with
Understood.
third.
Sure.
And the person, I asked this question before, and the person said, you know, I'm gonna go out and, you know, go break the guy's other law. What is a judge, what should be the proper result in that situation, in your opinion? I know you're a public defender, you're a DA, so obviously, just naturally, you won't have your own, you know, preconceived notions and your own personal experiences and biases. What do you say to that situation?
Well, without passing on your question, Senator, I think it's important to realize that these are, that's a limited circumstance. That's probably not in any way, shape, or form the norm. We're talking about that being a very, probably an exception, where someone comes into court charged with, as you say, an assault third, and says to the judge, not only am I getting out today, I'm walking over to my neighbor's house and I'm going to assault him again. Well, if he's stupid enough to say that, I'm sure there's law enforcement in the crowd, or the DA is going to get in touch with whatever law enforcement is in that town and let them know that this is likely to happen. There's going to be an order of protection issued. If that person violates the order of protection by going and assaulting that neighbor again, well, that's a felony, and it's likely he's not going to be released. In addition, any defendant who would say something like that in court might make themselves subject to a 730 evaluation, which they certainly can't be held anymore to have that done, but it's certainly something they don't want to have to go through. So again, there are these, and I will agree with all of you, there are these limited circumstances, there are these terrible stories, I get it. But when you take a look at, on the whole, on the vast, vast majority, this law works. It keeps people out of jail. It keeps people from losing their jobs and their children and their family. And I understand the small circumstances, the limited circumstances you're talking about, but I think that's going to be the rare exception and not the rule.
Yeah, and just as you said, you know, even before bail reform in this county, you know, the DA had a policy where they were not requesting bail on misdemeanors, nonviolent felonies. So
Correct.
bail reform or not, I mean, that was what was happening at least in this county.
Yes, sir.
I know that this bail reform law was meant to address things that were happening in, say, Rikers Island. There were a lot of stories about that. People held for years and years, which did not happen in our jurisdiction. So I understand that you're creating a law which has to apply to every situation, you know, not just some of the situation or most of the situations. Let me just ask you one final question, which I asked the DA. You know, it just came to me when I was watching this television show. I don't know if you heard my comments before.
Yes, sir.
And, you know, so you know, just to cut it short a little bit, so the DA said, well, you know, if you take a look at it, you know, across the 62 counties that we have, you know, you can make applications to withhold information, and sometimes you're gonna get it right, sometimes you're gonna get it wrong. What do you do in a situation where, you know, you have confidential informants, you have people who are witnesses in either very serious crimes or drug crimes, where there's an incentive to have the witness not testify?
So Senator, what you're talking about is the discovery reforms and the new protective order legislation that was in the statute. Okay, so in federal court for basically ever, They've had the ability for the U.S. attorneys to ask for protective orders when they felt that the information was so sensitive that disclosing it could result in danger, okay? First thing I want to highlight is that the new discovery reform doesn't call for you to give over addresses, phone numbers, places of business. It calls for adequate contact information, okay? Adequate contact information doesn't necessarily have to be addresses. It can be a phone number, a place where you can reach these witnesses, okay? That's number one. Number two, the vast majority of crimes in New York State don't have victims. And if we're talking about domestic violence cases, which obviously very serious, the person already knows who their victim is anyway, okay? But let's getting back to protective orders. In federal court, for years, there have been protective orders asked for. A lot of times what it ends up in is an agreement between defense counsel and the U.S. attorney as to how to use that information. Very few of those cases go to litigation because a deal gets cut. Listen, I'll give you that information. You can't turn it over to your client. If you do, the attorney's going to have major, major problems. I don't know many attorneys, in Erie County, in federal court, or anywhere in the United States that are going to put their license on the line and put a witness in danger by giving that information to their client. The same thing is going to happen in New York State. We're going to have agreements with district attorneys. We're going to have discussions about information that they feel is too sensitive to release. We're going to come to agreements, reasonable agreements on those types of cases. In the event we can't come to reasonable agreements on those types of cases, there's a mechanism for litigation. We'll go in front of a judge. They'll make their equity arguments. We'll make ours, and the judge will decide it. But ultimately, there's a vehicle to deal with those situations, and I just don't see that it's going to be that big of a problem, or as big a problem as it's being made out to be right now.
Should there be language in the statute which reflects what you just said, is that this information cannot be turned over to criminal defendants? Would there be some sort of repercussion to the attorney present?
It doesn't have to be in the statute, only because that's the way that it's going to be done organically. Those are the type of agreements that are going to be cut because that's the way it's been done in many other jurisdictions, many other states, and in federal court for many years. Thank you.
If there's nothing else, I just wanted to ask one question that was asked of everybody else.
Yes, sir.
Are there any changes you feel that you made this law, or is this perfect in your mind?
Senator, I'm going to defer on that. You'll understand that I find that this law is a huge positive. It's helping my clients. It's keeping them out of custody. And at this point, I don't foresee any changes.
It's fine the way it is.
In my mind, yes, it is.
Okay. I'm sorry.
So I'm not sure if you heard the testimony from Allegheny County Probation Department.
Yes, sir. I was here.
Do you have any thoughts about some of the points that she brought up about some of those intervention services there, that they're not able to do some of the things that address public safety and also help the offender at the same time?
Respectfully, Senator, I wasn't able to hear all of the details of those cases, at least the one case that she was talking about, but it seemed to me that there were a lot of places in that, in the timeline of that one offender she was dealing with where intervention could have made. This person was on probation. He could have been kept in custody.
Not that particular case.
In terms of intervention services with people not being in custody, I think there's plenty of opportunities to provide that type of service. I can tell you in Buffalo City Court, we've got a courts program. It's basically a clearinghouse facilitator to get people into treatment. We've got a very robust release under supervision program through the Erie County Probation Department. There are many places where people can get services intervening without being placed in the holding center or the correctional facility to wait for those services.
Perhaps, but they're not made aware of them until after arraignment. It's that interim period. After that arrest, emotions might be high. They might be coming off a high, have problems with detox, those types of things. It's that interim period.
You're talking about when an appearance ticket is issued before they get to court? Well, I don't know how to answer that question as to whether or not they'd be able to get the services. All I know is that there's an extremely robust service community in Erie County, and I think there's many opportunities for people to get the services they need.
Thank you. Senator Orr? Yeah.
I just want to make a statement for the record. You mentioned D.A. Flynn,
Yes, sir.
being supportive of this, and then you were asked a question about changes, prospective changes. And certainly, it's hard to answer that question, I guess, on the whole.
Yes, sir.
But something I wanted to just read, this just came down from the DA. This is a quote: "We got a little creative here, and we charged the attempted burglar." This is in relation to the Chilean nationals who were in Amherst, who were in county court again today. He said the burglary charges alone would not have been enough to hold the three on bail, but the lower charge of attempted burglary were, which we believe is or which, believe it or not, is a qualifying charge to set bail. This is again from the DA.
That's correct.
Now, again, how do you logically explain that? You'd have to ask your representatives in Albany that question. I have no idea how that is logical. So I think he's referring to the fact that a lower charge of attempted burglary is enough to set bail, but actual burglary is not. So that might be a change that could be logical from the DA.
Yes, sir.
No, ma'am, thank you. Anything else?
No, thank you very much, Senator.
Okay, thank you very much.
Thank you.
It's an excellent idea, thank you. I'm going to have, next up is going to be Bradley Mazer, Under Sheriff for Genesee County.
Good afternoon. Thank you for the opportunity today to discuss what effects we have seen already in Genesee County in just the first month of this new legislation. We've already had 3 high-speed pursuits in Genesee County. The first one dealt with deputies attempting to stop a vehicle from traffic violations. The vehicle continued through the streets of the city of Batavia. The vehicle was ultimately stopped. Both subjects fled. They were both apprehended. One of those subjects was found in possession of a handgun with ammunition in the magazine. Fentanyl and crack cocaine were recovered with a street value of approximately $500. I've spent a good portion of my career in narcotics investigations, and I can tell you that drug sales and violence go hand in hand. The second pursuit that we dealt with shortly after this pursuit, an individual led police on a high-speed pursuit from Genesee County into Monroe County. The individual crashed, and the individual was taken into custody. It was revealed that the individual was operating a stolen vehicle from another county. This individual was released on appearance tickets. In the first matter, these 2 individuals were also released on appearance tickets. And I'd like to note that they were not from our community, they were not from our area, and it's unknown what their true intentions were.
My name is Joseph Graff. I'm the Chief Deputy of the Criminal Investigation Division at the Genesee County Sheriff's Office. The Undersheriff asked me to come along today to talk to you about some recent cases that we've been involved in, and I'll just made some notes about a recent case that kind of has affected us at our office. In March of 2019, subject was released from New York State Prison after serving a full term for a grand larceny conviction. May of 19, we received a complaint for a suspicious vehicle parked in our community. Our deputies responded to that vehicle, located a subject inside that vehicle, which led to an ensuing investigation resulting in charges of criminal possession of a weapon 4th, criminal possession of stolen property 4th, criminal possession of a controlled substance 7th, and tampering with evidence. The subject at that point was taken for an arraignment, was committed to our local jail, and confined at the jail pending further court proceedings. While in our jail, the subject committed an assault 2nd charge as a result of a confrontation with another inmate. Again, was arraigned in court and recommitted to jail. In December of 19, that subject was released from the jail. Shortly thereafter, he was turned over to an adjoining sheriff's office who had warrants for arrest for that subject. And in January of 2020, a local police department in our jurisdiction was involved in an attempted robbery investigation involving a subject who attempted to rob another person with a knife. I'll just go through a few cases that came up since then. January 12th of 20, we received a stolen vehicle report. Days later, we received another stolen vehicle report. The investigation led to the development of a suspect, and our office was able to interview that suspect on January 23rd, who then admitted to both of the prior stolen vehicle complaints that had come in. Following that admission, the subject was released on an appearance ticket. One day later, we received complaints from a neighborhood about vehicles being broken into. That led to responding deputies going to the area, and a foot chase ensued, and the same subject who was arrested the day before and released on an appearance ticket was taken into custody. That night, the subject was not charged, as he would have been released anyways on another appearance ticket. The following night, we received a report of a stolen vehicle, which led to a high-speed pursuit through a local community, which caused thousands of dollars of damage to residents' vehicles and residents' yards. A pursuit ensued with canine tracking. However, subject was not apprehended that evening. A description of that person was obtained, which did match the previous arrest for the subject the prior evening. 3 days later, we received, again, complaints of vehicles being broken into. We had responding deputies to the area and were able to apprehend, after a short search of the area, the same subject whom we had previously arrested on the stolen vehicle charges. That subject, again, would have been released on an appearance ticket. However, at that point, the investigation from an adjoining agency within our community had come to a conclusion, and they were able to incarcerate that subject on the original attempted robbery charge from the beginning of January. Had not that investigation had been ongoing, again, this subject would have been released on an appearance ticket. So I just put together some notes about that case, just to kind of highlight some of the real-life instances of what we're dealing with now.
The other concern that I have, within our county, we have a theme park, Darien Lake, which holds concerts. These concert venues, we have approximately between 20 and 23 concerts per summer, and the venue holds about 22,000 people. Although it's unknown, I do have concerns, not only for the safety of our deputies, but also the safety of other concert goers, an individual knowing that he's not going to go to jail that night, that he could be released on an appearance ticket, in our discussions earlier about what constitutes assault second and assault third. So those are some of my concerns as we enter the concert season this summer.
Thank you. Any questions for Mr. Brown? Yes, Mr. Akers.
Thank you very much for being here. I had a discussion with the sheriff in one of the counties in this area, talking about, he told the story about, commonly if you pulled over someone, found drugs in that vehicle prior to January 2020, that person would be arrested and arraigned and either kept in jail or bail, and the drugs would be confiscated. That sheriff told me now, his district attorney said to him, due to the discovery, changes in discovery law, do not arrest that individual at this point in time, because if we do, we will not have time enough to test the drugs to make sure that they are in fact drugs within that 15-day window, and we would just have to let them go. So the only way to achieve this is to hope you can find them down the road. Is that something you're seeing, or a legitimate concern that you've seen as a result of this discovery change?
Yes, and it is a concern with the lab, the turnaround on the evidence being submitted. In the past, when I was working on narcotics, it would usually take between 4 and 6 months to get a lab result. So that is a concern. We have discussed that with our district attorney, exactly the way you described it, as far as releasing that individual until we can get a positive lab report, and then for the purposes of discovery and the new constraints of discovery, and then to locate that individual and arrest him.
And because it is now with the new law, I don't know if you go under discovery or bail, that only the highest level of drug offense is allowed to have bail. We had a correspondence from the DA saying that some very high level drug-related activity, it's hard to get that top level immediately upon release because evidence is not all intact. So they are finding that they have to let these dealers go because the case is not fully built, and again, try to find them down the road.
Just a quick question while we use that get ready.
Okay, sorry.
Do you have any stats yet for Genesee County in terms of non-appearances, or is it too early for that?
No, sir, it would be too early for that.
Senator Ward?
I'm going to ask a question because it was inferred by the last testify, or the last testimony. The population that you come into contact with that's in jail, that goes through, in your county, is it predominantly white, is it minority, is it a mix? I mean, without getting into specific statistics, can you give me a ballpark?
Genesee County, rural county, majority of the individuals we deal with would be white.
Sure, okay. And is there any political value that you see in letting someone sit in jail?
No,
Okay.
absolutely.
Just want to make sure.
Absolutely.
All right, any other questions? All right. Gentlemen, thank you very much for waiting also. We're coming up on our 2 hours here. Is it Catherine Yulee? Yes, if you could please, Catherine Yulee, Genesee County Justice Program Coordinator.
Good afternoon.
Thank you.
Genesee Justice is a unique department under the Sheriff's Office in Genesee County. We're restorative justice based, and we work with both a victim assistance program as well as we have a robust pretrial release program. And we've been doing this since the 1980s. Both of these populations, the victims as well as the offenders, are going to be negatively affected by the bail reform laws. Every morning we have a counselor, we have counselors that go to the jail and do evaluations on any newly incarcerated individuals. We do a bail evaluation looking for risk assessment. We look for residency. We look for unemployment. We look at mental health concerns, and we look at substance abuse concerns. This information is all taken in. We get a verifiable source to corroborate that information, and then we send that tool over to the judge to make the final determination. It's a scoring system, it's a numerical system, but it's always up to the discretion of the judge to release. If the person is released under our supervision, the judge has discretion to choose various conditions that individual has to follow. So it may be just staying, letting us know when they move and their contact information changes and not break the law again. It could be a substance abuse evaluation and to follow treatment recommendations, a mental health evaluation and follow those reservations. It's all the way up to possible curfew. So through the process of having that person released, we work with that individual to get a successful outcome. They contact us, we keep in contact with their treatment agency, and we are restorative. We want them to come out on the other side a better person than when they went in. Many times the sentence will be a prison sentence, a jail sentence, but throughout their time of release under our supervision, we stay in contact with them. And if they do have violations, we let the court know. Without having any of these individuals in jail, we can't do those evaluations. We can't recommend treatment. These individuals are put back out on the street without any help, any support system available. We see that the opioid crisis, the cocaine crisis, is going to be taking more lives. It was on a downswing. It's going to be going back up. Victims are frightened. Our victims are frightened by the defendants being able to return right back to the scene. Witnesses. We have witnesses that I'm afraid, are not going to be willing to come forward knowing that the defendant is going to have all their contact information. Bail reform is definitely needed, but this needs to be worked on together, and the judges have to have their input on some changes and some discretion that they can follow. Our judges work with us, our department, all the time. Our probation department contacts us if we've had a person under supervision when they're doing their pre-sentence investigation. Genesee County is a very collaborative county, and we've worked together well. There isn't one person that has been in the jail in a Rikers Island situation. They're seen every day, and if they're at all possible, they're released. So I look for a change in this present law to improve that for both victims and offenders. Thank you.
Thank you very much. Any questions?
Genesee Justice actually is bail reform before bail reform.
Exactly.
Genesee Justice keeps people out of jail and also at the same time protects the community. I wish that the authors of the bill had talked about release under supervision and Genesee Justice, because they would know that in many areas of the state, bail reform was already alive and well, just like in Erie County here, where the DA had decided not to ask for certain bail. This type of discussion certainly would have been very helpful, quietly, for that reform. But thank you for all the great work that you do with Genesee Justice.
Thank you.
Yes, thank you. Thank you for waiting. Appreciate it. I'm going to call up Lisa Thagard to speak on. Thank you for coming here today.
Thank you. First of all, thank you for allowing me to speak to you in regards to this bail reform. And my name is Lisa Thagard, as he stated, and I do have a bachelor's in sociology, which studies the human society. And with that said, it's a personal issue that hits close to home. And the reason I said this is because my son is affected by this. And that's one of the reasons why I want to share my story. And if I can say one thing, and I was hoping some judges would be here, and this is one of the things I wanted to say. There's a story behind every person. There's a reason why they're the way that they are. Stop judging. And I heard some information in regards to, there's programs out there that not being able to be addressed, and this is going on the addiction part of the bail reform. That Project Blue that we actually was given $1 million to help people with addictions when they are released to hopefully get back into society and be able to contribute, I feel is a waste of money. I'm one thing about accountability. If a person doesn't do their job, I don't feel they should be in that job. And therefore, we need to address that when you actually have the bail reform. And I'm glad Genesee County is here. And the reason I say that, because I'm a recovering alcoholic. And Genesee County is the county that sent me upstate. And the plus about the bail reform, if that was in effect when they sent me upstate, and I am not denying that I should not have been sent upstate, but if that bail reform was in place, I went to court thinking that they was going to extend my probation because I violated. And I'm not denying that you guys shouldn't have sent me upstate, but the way that you did it, my son drove my vehicle, a 17-year-old son, drove me to the court, and I'm thinking they were going to extend it. That day, I went to jail and was detained there, and one of the bail bondsmen was here. I was married at the time. My ex-husband, who was in pharmacy school in Washington, D.C., could not come home and be there for my son. My probation, the probation officer knew this. My attorney who was representing me knew this. Okay, so by him not being able to come home and be there for my family, I had at the time a 17-year-old, and at the time, I believe my youngest was 11 years old. And when it says it takes a village to raise a child, not one family member, not one friend stepped up to the plate to be there for my sons, which means they were basically thrown out to the streets. It was a classmate that actually saw at the time I was living in Cheektowaga on Mount Vernon. The mother of one of my son's friends, the younger one, took my son home and realized the lights was out because my son was embarrassed to tell them where I was at. And my landlord was being patient because he knew I was a good person to pay my rent. He was hoping that they would have released me. And it took her to take my son in. And unfortunately, because of my addiction, did not think about what would happen to my sons. Both my sons were exposed to things they shouldn't have been exposed. And when you are having addiction, you don't think about that. But I just felt that bail reform was in, that would have allowed me enough time to make arrangements for my sons, to be able to be put in place at homes that would have been able to look after them. The 18 months that I went upstate because I did the Lakeview Shock, which is a rehab part of the correctional facility, the 18 months was an important part of their lives that they can never get back, that I can never get back. And that's one of the reasons that I am there for my son in regards to his addiction. And that was the positive side of the bail reform. This is the negative side. My son, and I witnessed this, and I keep in mind, I said I'm a sociologist, which gave me the opportunity to see how the drug court was ran. My last conviction with the DWI, I was able to faithfully because I was determined. I admitted that I had a problem. I wasn't in denial. I completed the DWI court with no sanctions. A person with an alcoholic addiction at least had to have 10 or 12 sanctions. I was committed. Unfortunately, my son is not, because he's in denial. And to see that the drug court allowed him to go through a year, and mind you, my son, he's 31, a physical athlete. Since he'd been in drug court, he deteriorated. And I basically tried to even go to the DA to tell him if he's not in compliance with the court, every time he would have dirty urine, if he's not in compliance in the court, that's where mandation should have came into play. Because not only was he a threat to himself, he was a threat to others. Whenever he committed a crime, it was always under the influence. So that lets you know it was his addiction was the root of the problem. And that's something that they should address, and I felt that the drug court was actually not helping him. And when I use that, there's a time that my son has a plate in his face, never had an injury, medically, because he was under the substance. This is all when he was in drug court. He ended up getting stabbed in his hand. Anybody know when you get stabbed with a wound, okay, if the knife is dirty, you can bleed to death. And I truly believe my son is blessed for me to share my story to hopefully prevent no other family to actually go through it. My son was trying to climb up to my window each incident under the influence. On a second level, he broke his ankle. All of this is in drug court, and they keep on releasing him, and he was in Judge Russell, and at that time, I didn't know, thinking that Judge Russell was a good thing, assuming it was like DWI court. He's harm reduction, and I have a problem with that, which our sheriff, like he said, I would not agree with it. You're allowing someone to keep using a drug. Of course I wouldn't want that in my jail system. And I was hoping, and what mother, as they say, will want their child in jail? My son is basically safe. If he's not in compliance with the court, why didn't they mandate him? Okay, and then when my son actually realized he had enough, he told the Judge Russell he wanted to be sentenced out. My son was facing 8 to 10 months in jail. All I wanted was some clean time, because if you know my son, you talk to him when he's not, under the influence, he's an intelligent young man. My kids went to, like I said, Cleve Hill. They went to good schools. Okay, unfortunately, like they said, what's out there, the drugs is basically hurting our loved ones. And what they're getting today, what he's smoking is marijuana, they tampering with it. They putting whatever's in is causing them to act erratic. My son actually had an episode in Judge Russell court. It took 5 officers to have to restrain him. Okay, so this lets you know the seriousness of it, and to see that, and you keep wanting releasing him. And my thing, if they would have gave him the 6 to 8 months that he should have been given, like he was sentenced on January 2nd, okay? Since he was, he's sentenced, he had at least 5 episodes, whether with ECMC, officers, and then the last one, which I found was very disturbing. Okay, he got arrested where they end up taking, he had 100, his sneakers he had on, which was $100, whatever. They end up taking, I truly believe the officer took that to be funny, because my son is in the system, to try to teach him a lesson. Okay, so he had no shoes. And to know that he ended up going down to the drug court, which is Ronald Coleman, one of the persons that works with the drug court, that's where he got his pair of shoes from. So that's letting them know, y'all released him, y'all shouldn't have released him. He should have been sentenced to 6 to 8 months, and he at least got some clean time. Okay, because if a person cannot do it themselves, I feel it's the opportunity, the moral responsibility of the community to actually be helping that individual, because they can't help themselves. Okay, and I look at it when a person's breaking these laws, and there's a reason why they're doing it. Find what the root is, okay? And once you find the root, deal with it. Because I'm thinking, when my son was sentenced, we thinking he getting 6 months. Even he thought he was getting 6 months. And to be told in front of Judge Russell, he was sentenced out, charges dismissed. He was shocked. And then to look at the bailiff laughing at it, and then, because my son had a surprise, he said, Mom, I thought I was going to get some time. And then the person that's representing him laughing, it's a big joke. But the thing is, I'm trying to save my son. And not only that, I give information to them, hoping that they would share it to save somebody else's life. So this is the reason why I feel that the bail reform should be repealed, okay, looked at, amended, because not only that, it would help our community in regards to the safety of the bail reform. I truly do believe that.
Thank you so much. And thank you for coming here and sharing your personal story. This is why we're doing this, and we appreciate your perspective. And thank you for sitting here this whole time. Any questions? All right. Thank you so much. Thank you so much.
Thank you.
Okay. Again, we're running really long here. We've got the speakers that had confirmed before we were done, so we're going to call Joe Cardone, Orleans County District Attorney.
Thank you, Senators. I hail from Orleans County, a small county of 42,000 people, but we're surrounded by Niagara County, Erie County, Genesee County, and Monroe County, some 2 million people. And although we are only 42,000 people in our county, we have 2 state prisons. And I can tell you, I very much appreciate the opportunity to be here in front of you this afternoon. I appreciate the fact that you've taken from your time to be here. And unlike last year, where these new laws were passed as part of the New York State budget, as I understand it, with very little input from stakeholders, such as we have in the room today, there are some things that I think you need to take into consideration with respect to the impact of these laws. I was in New York City with DA Swanson last week. We were able to listen to DCJS, and they told us that over the last 3 years, crime reduction in New York City was 2%. Crime reduction in upstate New York was 9%. There had been a slight increase in New York City over the last 3 years in violent crimes, and it was down 4% in upstate New York. Over the last 3 years, murders in New York State have been less than 600. That's the first time in the history of New York State that murders have been less than 600 over a 3-year period. I'm sure you all remember in the early 90s when murders in New York City alone were approximately 1,600 a year. I think you're aware that in most of upstate New York, opiate deaths are being reduced, if not flatlined in most jurisdictions, and that is as a result of programs through our county jails that have gone into effect over the last 3 years that have been able to get these individuals into various treatment programs, and that's now going to all evaporate. And they tell us that methamphetamine is on a tremendous rise here in New York State, and that over the next few years, we are going to feel the impact of that for something, frankly, I don't think we're ready. You have to look at some other things that have happened during the course of the last few years that are going to have other impact on the safety of our community. I think you're aware that over the last 2 or 3 years, the Raise the Age laws have been phased into place, which makes young individuals increasingly not responsible for crimes. And I certainly understand that we want to try to help those young people that have just started their lives and are confronted with crime. But we need to be mindful of the fact that there are a lot of new procedures that were put into place as a result of that were unfunded by the state to a great extent, that have put a burden on the people and law enforcement throughout New York State. I can tell you in Orleans County, and I believe it's true of most of the upstate counties, despite the Crimes Victims Board in Albany having $178 million, which is more than it's ever had before, have reduced the crime victims programs in most of upstate New York. Orleans County last year took a 40% hit in what funds were available to our crimes victims unit. We're told that OASIS, I'm sure you're all familiar with, a state agency that gets 33% of every seizure and forfeiture that's done in the state of New York, that those monies are redirected, not going back to the counties to help them with law enforcement, but are being used for Medicare. And we're told that the agenda for this next year is to look at the parole situation. And the new motto coming out of Albany with respect to parole is that less is more. And that there shouldn't be technical violations of parole anymore, and that misdemeanors that are committed by those that are on parole should not be looked upon as a violation of their parole, and that we shouldn't be putting people in jail that are violating their parole. Well, in my judgment, parole is not a right, it's a privilege, and I would ask you not to consider such laws. I think we need to look at some of the problems that these new laws are going to create for us. I'm not sure if you're aware, but extraditions, where we have to bring people back into the state to prosecute them, are a county charge. And if you can take into consideration the fact that a lot of people charged with felonies and misdemeanors are going to be given an appearance ticket, and they're going to flee the state. And understandably, these are drug dealers that are coming from out of state, providing drugs into our county that I'm aware of, that are going to leave this state and put us through the expense. And I can tell you most extraditions cost between $3,000 and $6,000, that we're going to have to bear that cost to bring them back, and they're going to be on the rise. I just ask you to look at what happens with respect to extraditions over the next few years while this new law is in effect. And what is most amazing about that is even after we bring them back on these extraditions, we're not able to set any monetary bail. So they're going to be free to leave the state again and subject us again to the cost of another extradition. You know, I just, with all due respects to the counsel before me, don't understand this idea that we should not be able to give discretion to our judges. They are elected by our communities. They're people that obviously the rest of the community has some faith and respect in with respect to their judgment. And I can tell you, in the 28 years that I've been the elected district attorney in Orleans County, I'm not aware of judges abusing bail as might have happened in Rikers Island. I can tell you this, that on a daily basis, our office, the probation department, the sheriff's department receives a list of everyone that's incarcerated in our jail, and we're looking to make sure that the laws aren't violated with respect to the amount of time that they are doing in our jails. You know, previous counsel talked about the fact that he's concerned that his clients are not going to be able to go to work, and I guess the impediment that's being put upon them because of bail. Well, I can tell you, us prosecutors, we have clients too, and they're called crime victims. And it's awful hard to explain to them what it is that's going on in our state right now. For judges not to have the ability to use their discretion with respect to those that should be in jail while they're awaiting the outcome of their case, it makes no sense to me at all. It's an overreach by the legislative branch of our government into the judicial branch, in my judgment. I would like to talk about those things that I think you might consider. I really don't expect that the laws in our state are going to be changed, but I am glad that you're here taking your time to listen to the reforms that we need to make in the first month of these new reforms, as they call them. I think of reforms as being something better, but I frankly don't think that these laws are better. In my judgment, judges should have discretion in all felony cases to set bail. That includes drug cases. Mind you, that as the district attorney in Orleans County, I oversee our major felony crime task force, which is our drug investigators. And I can tell you that they talk to me daily, and they're very concerned about the fact that those individuals that used to come forward to them as informants about drug activity that's going on in our county want no part of it anymore. Within 15 days, we have to disclose those individuals' names, and we have to give them a way of being contacted. And if you don't think that that's something that's subject to abuse, frankly, I just think people are wrong. Why we would just give an appearance ticket to anybody who receives a DWI when obviously they're already in an altered condition, and letting them go right back out on the street, often to drink more, and not give a judge discretion, to at least keep them in jail until this individual is thinking clear again, is beyond me. and why we would let our laws apply to all vehicle and traffic offenses. Mind you, no bail can be set on. If someone goes out and commits a vehicular homicide, that person walks. He could kill a family of 6, and that person gets an appearance ticket to show up in court in the next 20 days. It makes no sense. We should be able to set bail with those that want to cooperate, or that don't want to cooperate with law enforcement. We have situations now where we're giving appearance tickets, and I think you're aware that even though we're giving appearance tickets, we still have to process these people. We still have to get their fingerprints. We still have to get a name and address that we can notify them by, under this new law, of future court appearances. And we are already running into individuals that don't want to give us their name, don't want to give us fingerprints, and don't want to give us a way of being in contact with them to advise them of their next court appearance. And don't you think a judge ought to have discretion under those circumstances to set bail? We should be able to set bail for those that don't show up in court. Right now, as I understand it under the new law, there has to be at least 3 times they don't show up in court before bail's going to be able to be set. And in my judgment, if somebody doesn't show up in court, a bench warrant should be able to be issued, and we should be able to pick them up. There, over the years, New York, frankly, was one of the more liberal states with respect to what its criteria was as to when bail could be set. It is, has been mentioned earlier, the purpose of bail is to secure somebody's attendance in court. In other jurisdictions, they're able to look at what danger that person is to a community, or what contacts that individual has with a community. None of those factors are things that we're able to look at in the state of New York anymore. I think you're also aware that under these new laws, defendants are able to set their own bail in certain circumstances. So an individual that is in our jail right now on perhaps a parole violation and has been, again, charged with another crime, when he gets before the judge, he wants his time to be running on that new crime he's committed, because he's going to be in jail anyway because of a parole violation. And at this point, we have defendants asking a judge, and this is happening on a daily basis, to set bail at $1, simply so that their time can run and they're going to be held less responsible when we get to the point of being able to resolve their case. It's making a mockery of our system. It's making a mockery of what it is that these good people in law enforcement do.
The judge set bail, the judge is not allowed to set bail. The defendant asks for $1 bail. Is the judge allowed to set bail if the law says you can't set bail?
I'm sorry, I'm not understanding the senator.
You said someone who's picked up on a parole violation for a crime, no bail is allowed under the new law. So if no bail is allowed, how can a judge set $1 bail if that's against the law?
No. What I'm explaining is a situation where somebody who's out on parole may be violated on parole for some particular reason.
Okay, I got it.
And he's sitting in jail. While he was out, he committed some other offenses, may or may not be related to why his bail, his parole has been revoked. And on that new crime, separate and apart from his parole, he's asking the bail be set at $1 so that his time is running with respect to the sentence on the new charge. Is it allowed?
Yeah.
That's part of the new law that was passed in Albany this past year.
If you're allowed to set bail for $1?
The defendant is able to indicate what level he wants bail at, whether it's 10 cents, 50 cents, $1, or $1 million. It's his choice, not the judge's.
Thank you.
It's criminal discretion. So there's criminal discretion.
It's the crime, the defendant's discretion. So, in addition to that, we have individuals that have been convicted of crimes in the past, have one or perhaps more than one felony that they've already been convicted of, and we're not able to set bail on those individuals. That just by the fact that the sheer fact that they have prior felony convictions increases the chance that they're going to be a risk of flight. So I would ask you to consider that as perhaps an amendment you make to the law whereby bail can be set for those that have previous felony convictions.
Okay.
So
Yes,
I
sir.
want to ask you a question. I want to thank you for being here and for waiting. I know it's always,
thank you
it's
for the
always hard
opportunity.
when you're the last one or one of the last ones, and I know we have more. So my question is, and I'm unfamiliar with this, so there's been a lot about domestic violence and the concern for domestic violence victims under this law.
Right.
Because while the goal of bail is to make sure people attend court, sometimes the goal of holding somebody is also to protect.
And
the
diffuse
victim.
a situation.
Right, and diffuse a situation. That's also, it was a reason previously. So under the law now, if there's a call, a DV call at a home where two people reside, and the person is, arrested and given an appearance ticket, what happens, or what could happen to preclude that person from returning to their home? Is there something?
Well, so a judge will issue an order of protection.
Okay.
But, as you know, an order of protection is a piece of paper that mandates somebody to do something, just as the laws are that we put into our statute books. And whether somebody wants to pay attention to that is their call. And frankly, we've had situations time and time again where people violate orders of protection.
Sure.
So they're not the deterrent that a lot of people think.
But there would always be an order issued, though, in that case.
You would sure hope so.
Sure hope so, right.
Yeah.
And then lastly, under the discovery, there was always a concern about the 15-day. There is a concern.
Yeah, a huge concern.
Has there been any cases that you're aware of yet in Orleans County where a case was dismissed or dropped because you were not able to meet the 15-day?
So, like Pat Swanson talked about, in Orleans County, it's always been our position that we give discovery at arraignment. So that's really not new for us.
Okay.
What's new for us is that you got to take into consideration that in today's world, you have officers that are wearing body cams. You have cameras that are filming a great deal of what's going on in society. And we're charged with getting all of that discovery and more than what we've ever had to give before. They virtually say everything within 15 days and get that to the defense counsel. Now, fortunately, NIPT, the New York State Prosecutors Training Institute, has put together what's called the DEMS program, which is an evidence management system that allows law enforcement to upload discovery to us fairly quickly. But we've had to develop a checklist of those things that law enforcement has to provide to us. And it's a 2-page checklist, and frankly, it's just jam-packed with as many things as we can possibly come up with for them to have to provide for us. The New York State Police's checklist is 14 pages that they have to process before they're able to send that case to the district attorney's office. Now, mind you, that all has to get to the district attorney's office within a very short window, turned around so we can redact information that may be in that discovery so that we're not providing information, personal information that shouldn't be part of that discovery, and put it into this DEMS program so it can be accessed by defense counsel within 15 days. That's a heavy lift. I'll also tell you that based upon the information we were provided for last week, that while you have enacted this law that says that we have to provide this discovery to defendants within 30 days, from what we're seeing, it's not being shown to their clients. There's no law that says because we have to give it to them in 15 days, that defense counsel has to show it to them within 13 days or review it with them within 13 days. And under this new law, we can't even make a plea offer until we provided that discovery and they've reviewed it with their client. So I'm not sure we're really speeding up the process.
Thank you very much. I believe the building is closed now, so we're running late, but we do have, I'm sorry. Oh, I'm sorry. Yes.
Sure.
Is this affecting your ability to resolve cases? I mean, I've heard in some jurisdictions that the VA will offer a reduction so they don't have to
Well, if they're doing it, they're not following the law. As I indicated, they have to provide discovery before they can make any plea reduction in a case. These new laws, and particularly the bail laws, are impacting our ability to get cases resolved. Frankly, in the last 3 weeks that I've been in county court, we've had individuals not showing up in court claiming that they haven't been notified under these new notification procedures that we have in place. And I'm not going to tell you horror stories, because I'm sure you're going to hear a lot of them over the next few months. Thank you.
Thank you very much. All right, we do have one more group, and if everybody needs to leave, go ahead. I know some of you, we have meetings that we're late for, but we're going to call up T.J. Phillips, the Kenmore Police Chief, and also Erie County Association of Police Chiefs President, and then Dan Hines, Denz, Town of West Seneca Chief of Police, and also representing the state chiefs of police. So thank you for coming up. Thank you for waiting so long. We appreciate it.
Thanks.
Thank you.
Thanks for having us. I'm not going to reiterate the arguments made, both arguments that have already been made about the bail, and I think we could go on and on about the bail. The defense has their argument that the bail reform is good for offenders, and it's not. My argument is it's not great for victims. I'll leave it at that for the bail. I would like to touch on discovery, the change in discovery. That is having a huge impact on all the police departments, especially smaller police departments like mine. I'm 25 sworn officers. And for us to produce all video, all paperwork, dash cam video, in-house video, booking room video, within 15 days on every arrest, it's near impossible. I don't know of one police department that has extra manpower. And I don't know of one police department that has extra money. We don't have it. So for this new discovery, now I have to assign somebody to handle discovery. We have to pay for storage, more money, cloud storage, all that video evidence. It's money and it's personnel. Where does that come from? It comes from a person that would normally, an officer would normally be answering calls, patrolling. Any way that you cut it, the new discovery laws compromise public safety at the end of the day. At the end of the day, that's where it ends. I'm going to turn it over to Chief Denz to wrap it up.
Well, I have the distinguished honor of being last, so I won't belabor the subject. My name's Dan Denz. I'm the Chief of Police for the Town of West Seneca, and I'm also on the board of the New York State Association of Chiefs of Police, and we represent over 500 law enforcement executives across New York State. We have heard anecdotal stories on both sides of this subject. Each side can make a very good argument for their own particular agenda. I would just like to sum up some things that we can all agree on. This is a home rule state, as you all know. We all have our own jurisdictional issues and our own battles that we fight within our borders of our own communities. However, across the state, the New York State Chiefs have come up with a particular platform on the bail reform that is basically 2 items, and they've all been addressed here. First and foremost is, if we don't repeal this legislation, at least let's readdress it and come to some common sense solutions to where we're at today. Implement strong judicial discretion again. We've talked a lot about dangerousness, criminal history, propensity to reoffend. One of the things that was just breezed over but is of serious concern is flight risk. We have a very transient population, especially where we are here in Western New York. We have our friends from the north coming through our jurisdictions, from Pennsylvania, from Ohio. These people oftentimes are arrested. They are now being immediately released and are flight risk. The judge cannot consider that anymore. So in my jurisdiction, I have all 3 major highways of Western New York come through my jurisdiction. I have the 90, the 219, and the Route 400. if we were to stop somebody on the 219 and they had a kilo of coke in the trunk of their car, and they were from Ohio, we would bring them back, they would be immediately released. Yes, we got the drugs off the street, but that person would never be prosecuted. Because frankly, if I was that person, I'd be beating feet back to Ohio as fast as I can, and I'd never come back to New York. All right, so there is no way to hold these people. The second part of our platform is, again, the review and readjustment of the crime classifications of what is bail eligible and what would be mandatory release. As you know, there's over 400 laws that have been affected by this. It was painted by a big brush, and everything fell underneath it. We need to go step by step and really re-examine what we should be mandatory releasing on and what we should offer bail. You know, there was a fella, our friend from the defense side here, who said there's a lot of misinformation. You know, he talked about bail, other people have talked about bail, how it was, and yes, it was, the purpose is to secure their attendance in court. One misconception that the general public has is that it is punishment. I have heard this from victims of people saying, well, you arrested this offender, but the judge, you know, only put $500 bail on him. Well, why is that? You know, and then we have to explain, well, no, it's just to secure the attendance in court. And then what is always left out is if somebody returns to court and finishes their court case, they get that money back. The court does not keep it. It may be applied towards a fine if one is there, if they are found innocent. That money is returned to whoever posts a bail. So that's just to clear up that misunderstanding. So finally, I would just like to wrap this up. We've been here a long time. You know, we've heard from a lot of different stakeholders here, and 4 things have been reoccurring here on this bail reform. Number 1, judicial discretion should be re-implemented. Number 2, re-examination of all the laws that are affected. Number 3 is attention to funding, and we know here in New York State that there's only so much in the pie, but you know, down at the local level, we're struggling with both the bail reform and discovery. And finally, as it was said earlier today, this was done not through a legislative process. This was done through a fiscal process of the budget. Nobody was allowed to have a seat at the table. We do not, as the law enforcement executives of New York State, we don't believe we should go back because it was such a wonderful thing. Yes, there can be changes made. We do not want to see people go to jail or sit in jail who shouldn't be there. I mean, we're still the good guys, all right? We want a balance between both the victims and the rights of the offenders. The scales are now tipped one way, or the pendulum swung drastically. We would like to revisit this and at least please give our organization, or at least the district attorneys, the chiefs, the judges, a voice on what you're doing. And that's all we can ask for from our side of the table. Thank you for having us here. Thanks.
Any questions? Thank you so much. Some of you want to speak. I apologize that, you know, we've run way over time, but I do want to give Colleen Christick, did I say that correctly? Sorry. Gentlemen, thank you very much. We appreciate it. An opportunity to speak, I think, from a slightly different perspective. So we appreciate you waiting all this time.
That's okay. Thanks for having me. My name is Colleen Christich. I'm a community researcher. It's close at the Partnership for the Public Good. And I'll just touch on a few things because I know we did go over time. First, I would just like to address the story of Khalif Browder because that was brought up a few times, and unfortunately the story was never quite correct. So there was a boy named Khalif Browder who was 19 years old who was accused of stealing a backpack, who was incarcerated at Rikers Island for 3 years without any trial because he couldn't afford the bail for allegedly stealing that backpack. At the end of those 3 years, the charges were eventually dismissed, and he was released, and several years later, he committed suicide due to all the trauma he sustained while he was in Rikers Island. And that really has touched off a lot of the bail reform efforts that we see here, and unfortunately that is not an uncommon story. That does happen a lot. There was someone here earlier who had a similar story, but he had to leave, but lost their scholarship due to being held on bail for months in Erie County, and then charges were dismissed. He was let go, but couldn't go back to college again because he lost his scholarship. So that is the whole reason for this effort. That is why it was necessary, is because many, many defendants, 64%, were being held in jails pre-trial. So not people were convicted of a crime, people who were accused of a crime but hadn't been convicted. So I think we are all on the same page that there is the need for reform. I've heard people say that. But what is really at issue is that what I think has not come across is that this comes down to the basic constitutional right to have a presumption of innocence until you're proven guilty, which has always been present for people who could afford to pay their bail. And that's the only thing that has been changed, is that now poor defendants have the same rights as rich defendants do. That's the only thing that's been changed with this law. And the bottom line that really comes across in that is that it was poor defendants and defendants of color that were being disproportionately impacted by this law, and in fact were not ever going to trial because they were being held so long in jail. That 95% of cases were resolved with plea deals. So of course there's going to be expenses with discovery, because now we're actually having trials, because we're actually deciding cases based on fact and not holding people until they decide, okay, I'll take the mark on my record because it'll get me out of jail, because I've been here for time served for this misdemeanor. So that's the bottom line. But what I've heard is that judges should have more discretion, that we should maybe use risk assessments, and that dangerousness should be considered to make the public more safe. There's a lot of issues with that. The main one is that judges have had discretion for many years, and they have not used their discretion to apply justice equally to people in front of them. We have done many studies showing that judges have, in New York, had the opportunity to use 9 different types of bail for many decades now, and they have only used 2 of them. So they weren't, until this bail reform issue was passed, they weren't using all the discretion that was available to them. In one study, judges made a decision about bail, and not even about bail, the whole arraignment, in 37 seconds. I sat in court appearances here in Buffalo, and in some cases the judge would waive the reading of the charges just so that they could get through the arraignment faster. They're not asking questions about how much people can afford. They're not asking if they have a job. They're not asking if they have school or kids to take care of at home. None of that was happening. Instead, people were getting $2,500, $5,000 bails for disorderly conduct, violations like that, which if they couldn't afford, which most of them couldn't, then they were sitting in jail. Also, there's a big discrepancy between judges. One judge that we observed set bail in 92% of the cases that he saw. Another judge set it 46% of the time. So who you were in front of made a huge difference on if you were getting bail set on your case or not. Also, white defendants had bail set on them 17% less than black defendants and 22% less than Hispanic defendants. So there was a racial discrepancy in if bail was set on the case. In addition to that, across the state, there's a lot of discrepancy in how the bail reform has affected the jail population, because in some counties where there are a lot more people being held on misdemeanors, the number of people in those jails since January 1st has been cut by up to 75%, whereas here in Erie County it was something like 25% reduction in our jail population, and that's due to differences between judges using bail in very different ways. So the bail reform affected each of these counties, and I can send you a breakdown if you're interested, in very disparate ways. So that's one reason why we shouldn't simply just trust that judges are using their discretion in ways that make equal application of the law. Finally, dangerousness has never been in the New York State statute, and crime rates are at a low. There's no reason to add a regressive policy into existence that we have never needed before. There's no reason to go back and rethink through something that at a time when we have the lowest crime rates we've had. Besides that, if you look at me versus someone else in this room, you might decide that I'm less dangerous than a man, for example, or an older person is less dangerous than a younger person, and it's almost impossible to suggest that a judge is able to decide, to predict that someone's going to commit a crime. We should not be asking judges to predict the future. A, that's impossible. B, it's unfair. You can't just put someone in jail because they might commit a crime. And that's what dangerousness statute is about. It's saying, oh, you are here because you were accused of maybe this very serious crime. You were accused of doing that, so I think you might be dangerous, so I'm gonna hold you in jail. That's totally against the Fifth Amendment. That's removing someone's right to due process and to being presumed innocent until they're proven guilty. Finally, the last thing, risk assessments sound like a great idea because maybe it would take that subjectivity out of it, but we don't live in a world where people are equal. We live in a society that's been infected by systemic racism for generations. So even if you have a form that looks like it'll treat everyone the same, people's life experiences are so different that that form is not going to have the same result on each person that comes before you. So for example, on the New Jersey risk assessment, it asks the number of times that person has been arrested before. Now in Buffalo in 2017, black residents were 86% of the arrests for marijuana possession, and white residents were 14% of the arrests for marijuana possession, even though white residents use marijuana at higher rates than black defendants. So that's to show, unfortunately, because of our society, black folks have to deal with the consequences of being arrested more often than white defendants, and that is reflected in the risk assessment. So they would score higher, black defendants score higher on risk assessments than white defendants do because of our society, not because of the risk assessment. But there is no way to create a perfect, objective algorithm that's going to determine someone's risk because of the society that we live in, which is inherently unjust. And hopefully, through continued reforms, we're coming out of that towards a society that is more just, but we're not there yet, so risk assessments won't work. Finally, the last thing I wanted to touch on was I'm really thankful that some of the law enforcement that was here today said that it's too early to tell. There's a lot of predictions of what might happen, a lot of dark stories about, oh, this could increase or this rate could increase. It's too early. We have not got any data. There's no proof to say that any of the dark outcomes are going to happen that people have been claiming will happen. So if you're going to make decisions about policy based on facts and not about emotion, then you need to let the reforms have a chance to work and then make a decision off of what you find from the data.
Thank you very much. Any questions?
Yes. There is some data available, not much. New York City, because of the resources they have, they're able to report data much quicker than smaller police departments. So while some of the chiefs, law enforcement people talked about, we just can't tell you about increased crime or not at this point in time. It's fair, and it does make sense to look in some cases at data. But here's what we've seen. And I will also go to the defense attorney. It's true when he talks about this is only a small population, and the reoffending and the person who says he's going to go out and beat the guy up again is a small circumstances, or is only a small amount of people, percentages. But so are criminals and crimes. The majority of people do not commit crime. It's those few that do, that victimize others, that then becomes a concern. In New York City, though, where the homicide rate has gone down each year for each of the last 20 years, the violent crime rate, as reported by the Commissioner of Police, has significantly gone up. The same is true in Nassau County. So here's really my question. So you spoke just a little bit about New Jersey, and yet I hear the governor talk about that is a great model, and the world didn't end. And you've got the two different things. You've got the risk assessment. None can be perfect. These bail changes certainly are not perfect, but you can do a lot of work towards putting a tool together that's scientific to remove a lot of the subjectivity from it, if it's done right. It's not easy, but it could be done. The other thing that's different with New Jersey is the significant investment in those supports, those essential pre-trial type supports, trying to provide some assistance, the pre-trial diversion, and things of that nature. New York has absolutely not done that, not one single dollar, unlike what we do with Raise the Age, where that's been invested. But here's really my simple question. University of Buffalo graduates from UB, goes back to his home on Long Island. There's a repeat DWI offender, that 6 felonies, 5 misdemeanors, 5 failures to appear, gets a recent appearance ticket for another DWI because of the new laws, and is out driving drunk again and kills this young man who's back home in Long Island. We've had somebody, I believe it was Albany County a week or 2 ago, was raped by an individual. And it goes on and on. And it's not fear mongering, it is fact. The media is reporting this. People aren't making it up. So the simple question is, it's a combination. What do you tell the victims? How do we fulfill our fundamental responsibility to help protect the public and ensure public safety? And how do you prevent those things from happening? If we don't, how do you do that, given
Sure.
the state of what the laws are right now?
Sure, so I'll respond to a few of those points. One is that, unfortunately, people have been being killed by drunk drivers before these reforms were passed. Just one instance of someone happening to do it after bail reform doesn't mean it wasn't done the same every other month before that. So just the fact that a crime is reported doesn't mean it's happening more often. And especially since that particular person would have been out of jail regardless if they were able to pay their bail. So there's no impact of the bail reform on that particular case, because if you have the money to pay a bail bondsman, you're out of jail under the old system.
But there's bail, there's been testimony, bail can be an effective tool. The pretrial diversion can be an effective tool as well. Some of the things that the judge can impose, that an individual has to behave a certain way or else face the sanctions of the court, can be an effective tool. Where we are now is well over 90%, here's an appearance ticket, just go back out and do whatever.
Right, and so pretrial services is a much better alternative than bail, and I'm glad that the reforms have put more emphasis on using pretrial services for felonies, especially because before the only tools judges were routinely using, in Erie County at least, was A and B bail, so cash or bond. And there was, I think, 1.5 positions of pretrial services in all of Erie County, 1 staff member. So hopefully that is expanded, because I think it is much more important to provide services, and that is where we've heard other people talk about today, that the underlying issues of mental health, substance use, chronic poverty, homelessness, things like that, is driving low-level crimes, and we do need more investment, especially in rural counties like Allegheny County that have no existing treatment center, that the jail has become the catch-all, and the criminal justice system has become the catch-all for failures in the public health system and all these other systems that now had been falling on jails. And I would argue that they are not the most effective place to treat mental health and substance use problems, as we've seen in Erie County with numerous suicides in the jails,
Fair point, but a
all
whole
of that.
different direction.
Exactly.
But for the sake of time, I'd love to keep chatting, but for the sake of time, I'll defer to my colleagues and the people who are keeping in this building that said we had to get out of here by 5.
Okay, Leader Flanagan.
Yeah, I appreciate you being here. I appreciate the testimony. I have a comment and a question. Comment is, there's been multiple references made to the Cleveland case for years. And I truly believe that Senator Gallivan played a pivotal role in reforms that were already made vis-a-vis raise the age. I do have to say I find it interesting that that case is brought up all the time as an example of failures in the system. But when I bring up the case on Long Island, people tell me that that doesn't apply.
Which case is that?
The case of Mr. Maldonado.
Oh,
And
okay.
I find that extremely troubling, because it makes me feel that there's being a double standard applied.
Mm-hmm.
You know, if there's one instance where it's applicable, this is a real-life case of someone in my county who was killed. And to say it's a one-off and it's not going to happen again, you know, if we're going to have a debate and we're going to have discussions about, well, here's a real case, then I'm going to point to a real case. My question is, you threw out a ton of facts. Or you threw out a ton of numbers. I would appreciate you sharing the background on that with Senator Borrello, since you spearheaded all this. But you said one thing that really caught my attention. You asserted that 64% of defendants are held pretrial.
Before bail reform, statewide. Yep.
So 2/3 of all cases in New York, defendants are held.
I believe that was the case, unless that was, I could check on this, unless that was only misdemeanors, but it was at least, I believe it was 64% of all defendants.
Okay, I would really like to know the sourcing on that. That seems to
Yeah.
me to be like an outrageous number. If you're right,
Sorry, I
fine.
can tell you I work with Colleen. That's from the Barrett Institute's study of the jail population over a number of years, and just coincidentally, it was the same number statewide. Pre-trial population was 64% of inmates, and it was the same number in Erie County. 64% of our jail population was held pre-trial.
Yeah.
Pre-trial defendants.
Well, jail.
Yeah, jail, not prison. So this is, the jail, you know, people are mostly there pre-trial. Because jail you only go to for misdemeanors. You go to prison for if you're, you know, felony or whatever.
Well, thank you very much for waiting and for speaking. Any other questions? So, thank you. Like I said, I think we had people from all different angles, all sides, and appreciate you bringing your perspective as well. And, you know, again, I think that's something that was not done prior, was to get input from stakeholders, from a variety of stakeholders. So thank you very much.
I appreciate you putting me on the list.
Yeah, thank you.
Yeah.